various parties were just making their way into the courts. But as of yesterday, the courts unanimously dismissed the petition, the petitioner's motion for leave to file supplementary statement of case and also to amend a paragraph, that's paragraph 28, in the statement of case in support of its motion for review. Now, the courts held that the application was not sanctioned by any rules of the court, and that on that basis the court unanimously dismissed that. The second ruling was that the court also unanimously dismissed the petitioner's motion for review on the basis that the application had not met the grounds for review as provided by the rules of the court. Now, the grounds for review, the courts gave two of such. One is got to do with that they show that there's been some bit of miscarriage of justice, which the petitioners failed to show in their arguments seeking for review of the earlier ruling of the court. The second ground has got to do with whether there's been new discoveries or evidence to the fact that it will affect the outcome of the ruling if a review is allowed. And according to the courts, the petitioners also failed to meet that aspect of it. So based on that, the court unanimously dismissed the petitioner's motion for review. So yesterday, the courts dismissed two of such applications made by the petitioners. We had 9-member panel who sat yesterday to look at all these applications out of the usual number that we know as 7. So after the rulings yesterday, the courts or the justices went back or recessed to reconstitute, and when they came back, they adjourned the case to today at 10. So that's what we'll be expecting this morning at 10 at the Supreme Court, and then we'll take you over to the premises now again to join Abdul Hai Mumin this time around to pick some thoughts from him and also from some of the stakeholders at the court premises. When we return, we'll be talking to our guest, Dr. Kwekwajiman Budu. Dr. Kwekwajiman Budu is a lawyer, is a law lecturer, and also the head of Law Center's Gimpa Faculty of Law. He will join us via Zoom or telephone for us to have a discussion as to what to expect today, because according to the courts, the case will be heard today. That's the substantive case itself. But let's join Abdul Hai Mumin, my colleague, who is at the premises of the Supreme Court. Mumin, good morning to you.
Many thanks for joining us here at the Supreme Court of Ghana, where the substantive case, the case of the petition brought before the Supreme Court by former President John Dramani Mahama, who was the presidential candidate of the NDC in the just ended 2020 presidential elections, seeking and asking the Supreme Court to annul the elections of 2020 and declare a runoff between himself and the president, who was declared the winner of that election by the chairperson of the EC. This case has been going on. They filed their case in court on the 30th of December, and a lot has since happened between that time and now. Today, as we prepare to witness what happens in court later on, it's instructive for us to take you back and let you know exactly what has transpired so far, especially yesterday when the court sat. Two main decisions were made. You may recall that ahead of the sitting yesterday, the lawyers for the petitioner, President John Dramani Mahama's lawyers, they asked the court to permit them to make certain additions to the review applications they had made earlier on. In addition to that, they were also seeking from the court permission to be allowed to replace paragraph 28 of that same review that they were seeking. When the court sat yesterday, the first thing that happened was to consider whether or not to allow the petitioner to make additional changes to the review. That was dismissed. The court then sat again, and again, before the court sat on the matter of considering the issues concerning the review, decision was, before a decision could be taken, the panel had increased from 7 to 9. There were 2 additional judges on the panel or yesterday, and they sat on the review issue. So the application for additional information to be added and for paragraph 28 to be replaced was dismissed. Then the court sat again, and at that time it was to consider the review itself. Lawyer for the petitioner, Mr. Chacho Chikata, made references to several instances where the Supreme Court itself had granted similar review processes. Lawyers for the first respondent, that's the EC, objected, and obviously lawyers for the second respondent, President Akufo-Addo, also objected to this. Again, the court went into recess, and when they came, the decision had been taken. The review application had also been dismissed. However, the lawyers for the petitioner were not too happy about this because, according to them, a similar review was applied for in 2013 when the 2012 election petition was ongoing. That the petitioner at the time, President Akufo-Addo, did ask for a review, and that review was granted, and so they did not understand why that's is a decision taken by the courts in 2013. The same court has gone against that same decision in 2021. However, we also do understand that the CI that governed the election petition of 2013 is totally different from that which is governing the election petition of 2021, and that's what has happened. Happened the last time the court sat. But again, today, as we prepare for the sitting, what is clear is that the witness for the petitioner will be in the witness box today to be cross-examined by all parties involved, and we find lawyers for the second respondent coming in right now. One of the lead lawyers, Mr. Frank Davis, is making his entry. Of course, we'll be speaking to Mr. Frank Davis after the court sits, and there he is. He's one of the lead counsels for the second respondent, President Akufo-Addo. So when court resumes sitting today, it is expected that the witness for the petitioner will be in the box to be cross-examined. What we have seen so far indicates that the witnesses for the petitioner are the General Secretary of the NDC, Mr. Johnson Esedun Ketia, and Dr. Kwesa White. Dr. Kwesa White represented the NDC in the EC's strong room, and he has made some allegations also against the EC, and so it remains to be seen how things pan out later this morning when sitting resumes, and we find many of the lawyers coming in now. And since this hearing started, since this morning started, what we have seen is that sitting usually starts at 9:30. However, yesterday the Chief Justice announced that today's sitting will start at 10. It is also instructive to note that this is the first time the court is sitting on a Friday since this hearing began. Again, there have been conversations and some controversies surrounding the 42-day deadline. Whilst the lawyers on the side of the second respondent especially say that the calculation for the 42 days starts from the day all parties filed their responses, and that these days include even weekends, and per their calculations the 42 days will end somewhere in mid-February. The lawyers for the petitioner have a totally different understanding of the permutations and calculations for the 42 days. According to them, these 42 days are the number of days that court actually sits. And so if you want to consider that, then today would be day number 6 However, going by the calculations of the second respondent's lawyers, this would have been day number 15 or thereabout. And there we have lawyer Yao Opong. Lawyer Yao Opong is one of the lawyers for the second respondent. He has also just arrived, and that means that very soon proceedings in court will begin. And of course, you will be given all the details right here on all of GBC's platforms, where we bring you all the unadulterated information. That's what's been going on here. We will take you through a bit of history in respect of the 2020 election petition, how it all started. Of course, you recall that on the 9th of December 2020, the chairperson of the EC did request, I beg your pardon, she did declare the results for the elections, and following that declaration, the NDC's candidate, former President John Dramani Mahama, thought that the declaration was not done fairly, and that it was wrought with errors. Indeed, the EC itself came back on more than 2 occasions to effect some corrections to the declaration. However, the claim is that these corrections do not essentially affect the final results as were declared by the EC chairperson. And of course, many more of lawyers and party officials arriving in court today. We find the General Secretary of the MPP, Mr. John Boydu, has arrived together with Nana Boache, who is the youth organizer of the party. They have also just arrived, and that tells you that very soon proceedings will begin. Again, it's instructive to remind you that the General Secretary of the NDC, who is the first witness for the petitioner, former President John Dramani Mahama, he will mount the witness box, it is expected largely so, to give his witness statement. He will be cross-examined, of course, first by the petitioner's lawyers, led by Mr. Chachu Chikata. Mr. Chachu Chikata. And then, if there is time, I'm sure that today, before court closes, he will also be cross-examined by lawyers for the first and second respondents as well. And so, on the first day in court, what happened was that the petitioner's lawyers had brought an application to the court. And this application had to do with a request to be allowed to make some amendments to the original petition. Now, some portions of the petition, according to the petitioner, had some clerical errors that sought to suggest that instead of the President Nana Addo Akufo-Addo running the elections, there we have the deputy, and he's now been nominated as Attorney General and Minister of Justice, Godfred Yabo Adami. He has just arrived in court, making his way into the court premises right now. Of course, Fatima Abubakar is one of the spokespersons for the legal team of the second respondent. She has also just arrived, and pretty soon, as has been indicated already, in the next 10 minutes or so, we will see the arrival of the judges in court, and the proceedings will begin. We have a lot more of party officials and lawyers arriving for today's sitting, because
All right, welcome back. So that was my colleague Abdul Hai Mumin at the premises of the Supreme Court. We just have about 10 more minutes for us to move back, and that's within the next 10 minutes. We'll be talking to Dr. Kwekwajiman Budu, who is a lawyer, law lecturer, and the head of Law Center's Kimber Faculty of Law, for us to have an understanding of what to expect today. It doesn't mean that a substantive case will be heard today, and what do we expect if and when the substantive case is being heard. We have him on the telephone. We'll speak briefly with him. At 10 o'clock, we'll take you back to the Supreme Court, this time around into the court for the hearing of the 2020 presidential petition. Doc, good morning to you, and thank you very much for joining us this morning.
Good morning, and happy to join you once again.
I hope you're fine.
I'm doing well by God's grace. I hope you're all doing well too.
I'm well too. Thank you very much. The first question, does it mean that now we're going to hear the substantive case, or the court is actually going to hear the substantive case?
So, from what we were told yesterday and from what we observed yesterday, after the court had delivered its ruling on the review application that the petitioner applicant had brought, the court directed that it was adjourning until today for hearing. So it is expected that hearing will begin today. And since the petitioner is the one that has brought the petition challenging the validity of the election of the second respondent, the petitioner will be incumbent on the petitioner to most likely open their case once hearing begins. But once again, let's wait to see what actually transpires when the court sits at 10 o'clock. But generally, that's the impression and the direction that we got from the Supreme Court in terms of the after their ruling and what they specifically directed to happen today.
What about those legal arguments that the respondents will wish to raise, the first and second respondents, even that the case doesn't even stand well?
I couldn't hear you. There's some noise in the background, so I really didn't hear your question.
I'm asking about the legal arguments that the second and first respondents are also seeking to raise. What about that one too?
You said the second respondent has done what? There are some people speaking in the background, so I really can't hear what you're saying.
I said the second and first respondent, they have some legal arguments to raise as part of the preliminary cases just to hear. And I'm asking, what about that one? Does it mean that that one will be heard later?
You mean the preliminary legal objections?
Yes, yes.
Oh, so from the directions that the court gave, I think the dates that it set out the issues for trial and gave some directions in terms of the witness statements that ought to be filed and other processes that ought to be filed. The court was clear that the submissions, the two respondents should go ahead and file their submissions in support of their respective preliminary legal objections, but that the decision on the preliminary legal objections raised by both the first and second respondent will be dealt with in the overall judgment of the court once the court decides the matter as a whole. So that is what we expect, and that's what the court itself said when it gave those directions. Ordinarily, when you raise preliminary legal objections, it would be heard before you move on to the substantive matter of the case. But given the nature of this case, the Supreme Court in its wisdom has decided that the respondents should go ahead nonetheless to file their submissions in support of their preliminary legal objections, which they have both done, and that the court will give its decision on the preliminary legal objections when it is rendering judgment overall in the petition. So that's where we stand in that regard.
All right, and let's talk about the 42 days. There's some bit of, let me say, misunderstanding here. Is the 42 days, can counting it, is it the days that court sits that makes up the 42, or it's the days that starts the case itself running without even the days that the court sits?
So I can't really give you a specific answer to that. What I can say is that Rule 69C4 of CI 99 provides that the court shall inquire into and determine the petition expeditiously, and the time for the processes in relation to the petition shall be as specified in the second schedule. And if you look at the second schedule in relation to Rule 69C4, it deals with the timelines for determination of presidential petition, and it lists a number of processes that ought to be done. So filing and service, The duration, it's expected to be done in January. The second thing, it says that on the 7th day, there should be appearance and answer. The third thing, it says that on the 10th day, there's pre-trial. The fourth is that on the 15th day, hearing will begin. The fifth is that on the 21st day, there will be the end of hearing, which means that hearing is supposed to last for about 6 days also. Then the sixth thing it says, and final thing it says, is that judgments will be given on the 42nd day. And the timeline for that, it stipulates that March. So that is what the second schedule of the petition, the CIA 99 says. So if you are to do your own calculation from the time the petition was filed, somewhere around 30th December, thereabouts, it would seem as though what the rules are saying in Rule 69C4, the second schedule thereof, suggests gives the timelines for when certain actions are supposed to be done and when judgment is supposed to be given. And as it stands right now, what the rules say is that on the 42nd day, judgments will be given, and that is supposed to be in March. That's what the rules say, that March, 42nd day judgment, and it's supposed to be in March. So it depends on how you calculate the days to arrive at that 42nd day being in March. I don't want us to delve into matters that may be may lead us into different spaces we don't want to be in. But what I can say is that that's what the law says, that the 42nd day is supposed to be judgment, but the duration of the timeline for that, it stipulates March without saying much.
Okay, we'll quickly go to the Supreme Court. The justices just are about to take their seat, but just a quick one. The parties were asked to file their witness statements, and we also get to understand that these witnesses will be cross-examined in the witness box. What's the difference between the witness statement and cross-examination?
Oh, witness statement is a statement that you make, essentially testifying to certain facts that are within your knowledge as an oath. And what it is that it's sometimes you may be asked to file a witness statement in lieu of the whole examination and all that. But cross-examination is different in the sense that if you file a witness statement, for instance, that is your testimony in relation to the particular matter. The other party is entitled to cross-examine you on the basis of your own witness statement to ascertain the veracity of the statement that you are making. So that's what it is. The witness statement is your own testimony, and cross-examination is when the team gets to examine you on the basis of your own statements to ascertain the veracity of the statement that you've made.
So can there be, can we have a witness statement without cross-examination? Or the other way around?
Let's wait and see what happens in court. Don't be too quick to jump the gun.
It's just a question. It's just a question. I mean, it's just a question. Whether we can have a witness statement without cross-examination or have cross-examination without witness statement.
It depends on the court before which the matter is and the directions that have been given in that particular instance. And since here we're referring to the Supreme Court and the election petition, the procedure may be slightly different from that which we see in ordinary court proceedings, because like I said, in under normal circumstances, legal objections will have been heard before the substantive matter, but we're told that the court will give its decision on the preliminary legal objection when it's given its overall judgment. So let's wait and see what actually the process that the court would apply in this particular instance.
On a general term, which one stands out when determining cases? Is it the cross-examination process or the witness statement? Which one?
What do you mean stands out?
Stands out in the sense that would determine the issues and the facts raised. Would it be the fact? Yeah.
No, you're making your case. So you have brought a matter to court, and you're testifying that these are the facts that are within your knowledge, which establishes your case. That the land belongs to you. For instance, it's a land issue. The land belongs to you. You acquired it on this date. You did the necessary administrative or legal processes to get it in your name and all that. Then you've testified to that effect. That's your case.
Yes.
So the opponent or the opposing party also has the opportunity to then cross-examine you. So examine you on the basis of your statement that you've made. That so you said you bought the land on this so and so from this. Was it registered? When was it registered? Those kinds of things, just to essentially ascertain the veracity of what you were saying and probably punch holes into your arguments. So your statement or your witness statement is what you believe are the facts that establish your case. But because it's not just you going to court, you're bringing someone to court, the other person will have or may have the opportunity to examine you on the basis of your own statements to ascertain whether or not what you're saying is the actual fact. That's what it's all about.
Okay, so in other...
Respectfully, my lords, writ number J1/5/2021, John Dramani Mahama versus Electoral Commission of Ghana. Nana Ado Dankwa Akufo-Addo. John Dramani Mahama is representing. Johnson Asiedu Ketia, my lord, is representing the petitioner. Lords, Jane Mensah is representing the first chairperson, representing the first respondent. Peter McMahon, my lord, is representing the second respondent.
Having difficulties hearing you.
If your lordships please appear for the petitioner with me, my learned friend, Tony Lither. Okay.
May it please my lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somoa Asamoah.
If it pleases your lordships, Akoto Ampao appears for the second respondent. My lords, with me are my colleagues Frank Davis, Kweku Esirfi, and Yao Pong.
My lords, our first witness is ready. We have indicated that depending on the response to the request to admit facts, there may be a supplementary statement from him. I don't know whether your lordships want us to make a formal application for that supplementary statement, or whether, based on our indication in the statement, in the witness statement that he's filed, once we confirm the status of the request to admit facts, that will be taken as granted, because, I mean, I just want to be clear, so we are guided appropriately. I'm sorry?
We want to take the witness first.
Very well.
Bible. I, Johnson Asiedu Nketia,
do in the name of Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give
that the evidence I shall give
in this case
shall
be the truth,
the
the whole
truth,
and nothing but the truth.
and nothing but the
So help me
truth.
God.
So help me God.
I lost SOD in English.
My lords, I believe the procedure, since it's not expressly provided in CI 99, I believe the procedure is as provided in CI 47 in respect of witness statements being. I just needed to be clear, maybe. So we're getting a copy of the file copy of the witness statement. Yes, so that we can, what we have filed. I'm sorry.
And then we adapt it as his evidence in chief, and then cross-examination will follow.
Yes.
Just so that we are not caught by time, we have objections to certain parts of the witness statement, and we would apply to the court to have those parts struck out as not relevant nor based on the pleadings of the petitioner, or otherwise scandalous and prejudices unfairly.
Mr. Kotuampa, the witness is here to identify the witness statement, so just wait.
No, I'm just serving the court with notice, because it is sometimes assumed that if you keep quiet and you tender it in, then you are caught.
Mr. Kotuampa, we don't tender evidence. So when it comes to the box and he relies on it, after he has been sworn, he relies on it, then it becomes evidence. Then if you have any objection, you can raise it. Yes. As it is now, it is not evidence before us.
Please give your full name to the court.
I'm Johnson Asiedu Nketia.
And you have filed a witness statement on behalf of the petitioner.
Yes, my lord.
Can you identify what the deputy registrar has made available to you and confirm that it is the witness statement that you have filed?
Yes, my lord. This is a witness statement that I have filed.
My lord, we wish to tender that witness statement, or it's adopted by the, yeah, very well, very well. That's the procedure.
Yes, my lords, as I've said, we are objecting to certain paragraphs or parts of some of the paragraphs in the witness statement of Mr. Johnson Asiedu Nketia on the ground one, that they are not based on the pleadings. 2, they tend to unduly prejudice some of the parties to this suit and are scandalous, and accordingly we would pray that those paragraphs or parts of those paragraphs be struck out as such. Yes.
The grounds of objection. The first one was that it was not based on the pleadings.
Yes.
And the second one, unduly prejudicial. And scandalous. Yes. What is the third one? The third ground.
Is it scandalous?
Yes.
Oh, okay.
My lords, I believe that it's well established that a party's evidence.
But could you identify the paragraphs first?
Very well, very well. My lords, we are referring to paragraphs 21, No, I have it. Yes, Valerie.
You have set out 3 grounds. Which of those 3 grounds is applicable to paragraph 21? What I'm asking you to do is tell us your ground of objection within the 3 before you start your argument, so we can follow you.
Hold on, please. My lady, paragraph my lady, paragraph 21 is not pleaded. There's nothing in the pleadings to that effect. Yes. The pleadings, this evidence that they're seeking to lead is not borne out by the pleadings, my lady.
It's not based on.
It's not based on.
Okay.
My lords, we also object to.
Do you mean the reference to the website in that paragraph?
It says moving and changing and subsequently deleted. These are very material facts. If they sought to rely upon it, they should have pleaded it.
Yes.
My lords, we also wish to take objection to paragraphs 6 and 7 as completely out of place. Out of place in the evidence in chief.
What does that mean? What does being out of place?
It's not admissible, my lord, because yes, because it's not admissible because it was not part of their pleadings. Their lawyer may raise that matter before the court in address, but this cannot be part of their evidence.
Paragraph 7 or
6 and 7.
My lords, we also take objection to that portion of paragraph 25, which starts on page 6 of their witness statement. Thus, the first respondent, in respect of the declaration of presidential election, betrayed the determination on the part of Mrs. Jean Adukwe Mensah as returning officer for the presidential election, and certain officials of first respondent to have second respondent installed as president of Ghana by hook or crook. My lords, we think that this is highly prejudicial and scandalous. There's no pleading that can support this type of scandalous and prejudicial piece of evidence, and we pray that it is struck out on those grounds. My lord.
Yes, so we are clear. Is it the sentence starting from page 5? In fact,
yes.
So it starts from page 5.
Yes, you are right.
Ends at
page 2. Yes, it starts from page 5. Right. Relax. They're writing. My lords, our next objection relates to paragraph 26 from the sentence that reads, the chairperson of first respondent, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Ms. Jean Adukwe Mensah, has a close familial relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. My lords, we pray that this part of paragraph 26 be expunged as scandalous, prejudicial, and not based on the pleadings. These are very serious material allegations of fact, and they were not pleaded.
Yes.
Well, the next part we take objection to relates to paragraph 28, which the portion reads, the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondent seeking to justify after the event Mrs. Jean Adukwe Mensah's 9 December 2020 purported declaration, and that undermines the whole attempt at correction of what was indisputably an error and in error-driven declaration, and shows, and my lord, that's a critical passage, shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast in the presidential election.
So does your objection start from the CPC or starts from simply being?
No, it starts from shows, but you can only understand the shows if you relate to it to what comes before. But the specific objection relates to the showing that the figures were simply being cooked. My lords, we say that this portion of paragraph 28 is extremely prejudicial. No facts have been pleaded to that effect and ought to be struck out accordingly. My lord, paragraph 30 of the witness statement. My lord strangely seeks to suggest that the first respondent, because of his bias in favor of the second respondent, somehow.
Could you tell us what you are objecting to?
The basis.
The
whole of.
The whole of it. Yes, the whole of paragraph 30. My lord, it seeks to suggest that the new regulations were organized by the first respondent with the object of ensuring that the process of collation and aggregation of votes were introduced without any good reason. My lord is talking about a piece of legislation. My lord, it is the witness may not speak to the legal validity of a piece of...
Mr. Kutampo, so is it your objection that it's not based on pleadings, or that it unduly prejudices, or it's scandalous? You've told
My lord,
us
it's
three
not
grounds.
based on the pleadings, nor is it, and furthermore, it is unduly scandalous. And my lord, our next objection. No, I don't want to go there. Our next objection, my lords, relate to paragraph 32. My lords, this was not pleaded by the respondents, the petitioner, and my lord, it relates to 275 summary sheets results. My lord, nowhere in the petition has there been any reference to any 275 summary sheets. And the petitioner had all the opportunity to do so if he intended to rely on this evidence. In the trial. He failed to do so and is seeking, through his witness statement, to improperly introduce it through the back door. Should be, and we pray, therefore, that it be struck out. My lords, indeed, if your lordships take a look at the petitioner's amended petition, even exhibits were attached to the petition when they should not have been. And so they had every opportunity, even at the time of filing their petition, to follow that flawed tradition. But they didn't. And now, when they asked to write their witness statement, they introduced this huge piece of evidence which they hadn't pleaded. We ask that it be struck out as not based on the pleadings. And consequently, paragraph 33, which is a consequence of paragraph 32, should also, in similar fashion, be struck out. I hear you. My lords, as we've indicated, it is well established that a party's pleadings are fundamental in determining the case he or she intends to make during trial. The party's pleadings also notify the other side of the case that he will meet in court. My lords, the significance of pleadings have been set out very clearly in the case of Hammond and Odoi, 1982-83, 2 Ghana Law Report 215 at 1215 at 1235 to 1236. My lords, I know that this statement of the law is very well known to your lordships, so I will not detain you with reading it. My lords, I wish further to refer your lordships to the case of Adejumo versus Abegunde and another, reported in 1965 Ghana Law Reports 499, 1965, my lords, Ghana Law Report 499. which holds that in holding one, now this is the Supreme Court, holding one to the effect, quote, although evidence is inadmissible to prove material facts which have not been pleaded, yet when such evidence is adduced at a trial without objection from counsel, the trial judge is bound to take it into consideration. My lords, we are making this objection so as not to fall into that trap. And my lords, we wish, in addition, to refer to the evidence decree. Where is the evidence decree? Evidence Act now, my lords. Evidence Act. Here. Section 51, my lords, which reads as follows: for purposes of this decree, relevant evidence means evidence including evidence relevant to the credibility of a witness or hearsay declarant, which makes the existence or non-existence of any fact that is of consequence to the determination of the action more or less probable than it would be without it. And sub 2 reads, all relevant evidence is admissible except otherwise provided by any enactment. And sub 3 states, no evidence is admissible except relevant evidence. And my lords,
Section I'm not clear what lessons you want us to draw from
my lord, I'll shortly demonstrate if I'm permitted. Section 52 B states the court in its discretion may exclude evidence, relevant evidence, if the probative value of the evidence is substantially outweighed by the risk that the admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. Now, my lords, the relevance of this piece of these provisions of the Evidence Act is that they confirm the position that any evidence that will be led must be based on the pleadings and be related to an issue in dispute. And that pleadings, evidence that spring from nowhere surprises the other party, and where they do cause, therefore they provide a danger of substantial or unfair prejudice, may be disallowed by the court. And that is why we believe it is relevant. My Lord, it is for these reasons my Lord, with all due respect, my attention has been drawn to paragraph 37 also. Yes, the last of any paragraph, where the witness states, I quote, "This conduct of certain officials of first respondent in padding the votes of second respondents is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of the first respondent to have second respondent unconstitutionally and unlawfully installed as president." My lords, this paragraph is extremely scandalous, and what makes it worse is that apart from the so-called 4,000 plus padding that they allege, and they have not provided any further evidence or made any further pleading, indicating that there's a well-hatched and sustained pattern of manufacturing numbers unrelated to the votes. There's nothing in either their petition or there's nothing in their petition to that effect. My lords, I think it is significant that whilst the petitioner has been making these really scandalous allegations, he has not provided one shred of evidence of his own tabulation of votes. Nothing throughout the petition, not even in the witness statement.
Mr. Kutuampa, you take advantage of that. Why are you worried?
No, my lord, I'm saying that to show how totally unacceptable paragraph 37 is, and it ought to be struck out.
Mr. Kutuampa,
yes.
Let me chip in. You see, the pleading is different from evidence.
Yes.
Pleadings can be struck out on the basis that it's scandalous. Yes. But this is evidence.
And my lord, if it cannot be struck out, it should not be admitted.
No, if a pleading is scandalous.
Yes.
Yes. It is a basis for striking out.
Very well.
Yes. But the evidence is quite different from a pleading. Except that the evidence takes its roots from the pleading.
Yes, my lord. And our case is that these pieces of evidence are not based on the pleadings.
No, but if you... Yes, you must know the basis of...
My lord, they are not based on the pleadings, and they should not be admissible. Being scandalous. My lord, we pray accordingly.
As to what is wrong with paragraph 6 and 7? Paragraph 6 and 7. Yes, what is wrong with that? This is a fact.
Look at it carefully.
Yes.
Yeah, what is wrong with that?
My lord, our view is that those two paragraphs are not matters for his evidence in chief.
They are not matters of for evidence in chief.
Yes.
No. So assuming we are doing oral trial and the witness is in the box, can't counsel ask him whether in the course of this trial he's filed notice to admit? Can't counsel ask him?
My lord.
Or whether in this trial he's filed interrogatories? Can he be asked?
My Lord, in the first place, we want to make the point that the witness is a witness. It's not a representative of the petitioner. He's a witness, my Lord. And if your lordships look at the witness statement, he doesn't indicate that he has a power of attorney and he's speaking on behalf of the petitioner. He is a simple witness of the petitioner.
To find out. When you led him, he said he was on behalf of the petitioner. So I was going to ask.
He's a witness. He's a witness.
He's a witness of the petitioner. Okay.
Not more sticky. Yes, my Lord.
What is your view about these two paragraphs? Because my understanding of why we are here is that we are dealing with the validity of the election of a candidate. And when I look at the evidence, in 32 and 33, the witness just stated numbers, application, 275 summary sheets, 30,000 and 30 million, 218, and left it at that. How would that affect your case? When there's issue, you see, we are not dealing with the High Court trial. We are not in the High Court. We are in the Supreme Court exercising a special jurisdiction over the validity of election of a candidate. So you have to limit everything, your submissions and your cross-examination, to the validity of the election of the candidate and not a general trial in the High Court. So you're complaining about 32, 33. How would that affect your case, the validity of the election of the candidate? Has the witness made any assertion that because of that, votes and other things and whatnot? So you look at it, if there's nothing, let the trial proceed. Otherwise, we'll be going through this banter and we'll spend the whole time raising objections and this and that. So let's focus on why we are here.
My Lord, that is precisely what I'm trying to do. My point, my Lord, is that the petitioner in his petition has never said anything about summary sheets. Indeed, the petitioner in his petition, in our view, has not challenged the validity of the election. It has simply picked on some errors in the announcements and the tabulation of the results. He has not provided...
And in these two paragraphs, 32 and 33, the witness is also not saying anything about the validity of the election.
Yes.
So why not keep quiet over it? That's what I've been telling my students in advocacy lectures.
Yes, my Lord, we will not keep quiet over it because it could be prejudicial. It may cast an unnecessary cloud over the elections. It is not being pleaded, and my lords, I believe that they cannot lead evidence that is contrary to their pleadings.
Thank you.
But I want to know whether Mr. Minuvo has something to say about the witness statement. Yes, Justin.
Yes, my Lord. My Lord, I have nothing more to add to what Mr. Kotuampo has said. Thank you. I associate myself with his submissions.
My lords, we have to deal, I believe, with a very practical issue before I get into the responses. Quite a lot of objections have been raised, more than 10, I believe. If it were a trial in which oral testimony was being given, in evidence in chief, there would be a series of objections at different points, and then one could take it up. And the practical difficulty I'm talking about is that as he was raising the objections, we were busy trying to deal with it. And we're frankly not, I should speak for myself, I'm frankly not sure that I have listed all the objections.
Mr. Chikata can help you. Mr. Chikata, we can help you.
Yes, very well.
We captured them all.
Yes, very well. So what I was going to say, my lords, is that as we proceed with the responses, we may need to come back to your lordships for the statement that you have recorded in respect of the objections, so that the answers will be appropriate in terms of what your record shows. That's what I meant by the practical solution to ensuring that we are addressing all the objections. But we're ready to respond to each of the objections, and guided by your record of the objection.
It appears the first objection, I hope you recorded the basis for the objection.
As I said, we're trying hard to record it. But
no. I know that it's very difficult to get the very paragraphs he referred to. Yes, I'm talking of the grounds for the objections, which were one. That it was not based on the pleadings.
The two grounds that he said at the beginning. Yes,
thank you. Yes, the first one was in respect of paragraph 21. Paragraph 21. Then the second, we went back to paragraph 6 and 7.
Yes.
Yes. Then he went to paragraph 25. Paragraph 26.
25,
the portion, not the whole.
From
the latter part of paragraph 25. Yes. Yes. Then he went to paragraph 26. Then went to paragraph 28, paragraph 30, paragraph 32, paragraph 33, paragraph 37. Yes. Then I think that is all. That is all. Please, yes. Can I go over it?
I have the paragraphs, but as I go on, the particular ground that he gave for each paragraph, I may ask for
no problem. No problem.
Yes, I have the paragraphs all right. Now, my lord, the first paragraph, and my lord, I start off with the fairly elementary statement of the law that pleadings are not meant to be evidence. And my lords, Rule 7 of Order 11 makes clear that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for a claim or defense, but not the evidence by which those facts are to be proved. And the statement shall be as brief as the nature of the case admits. Now, my lords, that's fairly elementary and well-known rule. And if we take the various objections, paragraph 21 is that, and paragraph 21 follows paragraph 20. So if I may first refer to paragraph 20. In this unsigned press release, first respondent introduced new figures for the total valid votes cast in the presidential election held on 7th December 2020. A copy of the said press release is attached and marked as Exhibit B and was available on first respondent's website, www.ec.gov.gh, as of 11:45 GMT on 29. So even as late as just before the petition was filed, we were pointing out that that document was available. And paragraph 21 is making reference to the fact that following that press release, the results being published by first respondents on this website became moving targets. Well, that's evidence in respect of what happened to the numbers that were provided for in paragraph that were mentioned, that were alluded to in paragraph 20, and becoming moving targets, subsequently deleted the changing figures from the website. That is material evidence that undermines the figures that were in that press release. Because there were figures in the press release, as we indicate, an unsigned press release that's, again, very, very clear. And subsequently, those were themselves being changed. I cannot see how this is immaterial. And my lords, particularly in a situation where the witness statement of the first respondent, that witness statement itself has different numbers from the numbers in the press release and the numbers in the declaration. My lords, I cannot, with the greatest respect, see how evidence about changing figures is not material in these proceedings.
Mr. Speaker, that is not the point. He said it says that this paragraph 21 has not been pleaded. It doesn't take its source from your pleadings. So perhaps if you look at your paragraph 28 and 29 of the petition,
yes,
you may be able to respond to it. But the ground is that it has not been pleaded.
Let me just...
Yes, on the pleadings.
Yes.
If you look at your paragraph 28 and 29, yes, so look so that you can help it.
My lords, indeed, in our paragraphs 28 and 29 and 30 of the pleadings, we state on 10th December 2020, an unsigned press release of first respondent claimed that its chairperson, Mrs. Jean Adukwe Mensah, had inadvertently, in quotation marks, used a figure of so-and-so. And then we continue in 29. In this purported corrective press release, first respondent introduced two completely new figures for the total votes cast in the presidential election. Thus, there was no correction properly so-called. Since to be valid, a correction of a prior mistake must correctly name the mistake to be corrected. In this case, the mistake to be corrected was itself mistakenly stated. The numbers so-and-so are completely different. And then paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. That is pleaded. And then it goes on in paragraph, it goes on paragraph 31. I'm sorry.
So go to paragraphs 6 and 7.
In paragraph 6 and 7, my lords, and your lordships will recall that in following your orders in terms of the filing of the witness statements, we actually drew attention to this issue of the request to admit facts, issues which normally would be part of the pretrial and which therefore affect how we prepare a witness for the trial. So, my lords, the point of paragraph 6 and 7 is precisely to indicate to your lordships the parameters within which his evidence is are being placed, because those parameters are.
We are worried because you see, Mr. Esiedu Ketia is not the petitioner. He's not a party, strictly speaking. He's just a witness, as you rightly pointed out. So let's look at it in that.
Yes, but my lords, he is a witness of the petitioner, and as a witness of the petitioner,
he can smite everything in the proceedings.
He can, yes, he can. My lords,
as a witness,
he can swear to matters that are within his personal knowledge, and those matters include processes which he is aware of. I mean, those processes are in fact a matter of public record, literally.
Because you see, we don't want, sir, we don't want a situation where, under cross-examination, a question is put to him. Do you know anything about notice to admit?
My lords,
no, the situation can arise because you see here, he is or not.
My lords, he
is or not,
and I'm sure that he will be able to take care of himself on oath.
No, we want to avoid a situation where maybe.
No, my lords, with respect,
we just want to streamline the way things should be done.
Yes, and my lords, respectfully, my lords, that's why I respectfully.
Let's move on, please. Let's move on.
In fact,
well, my lords, frankly, there is no difference in terms of these particular paragraphs, because the petitioner is not himself the lawyer filing those processes. The petitioner, yes, but the petitioner gives the instruction, and a witness of the petitioner, who is as aware as anybody else of those processes, can speak to those processes, because he's a witness of the petitioner, and as a witness of the petitioner, he familiarizes himself with processes that are filed. And in fact, more importantly, as a witness, and the point of those paragraphs is very clear, as a witness, he is indicating to the Honorable Court that I'm aware of these, and that is guiding what I have to put in my witness statement. That is part of the point. And my lord, and that is why, in fact, before he went into the witness box, I did draw your lordship's attention respectfully to the fact that we wanted guidance on whether we needed leave subsequently after those issues are resolved with the search that we're making. And your lordship said he should go into the witness box. So my lords, I have no doubt that the witness is able to address those issues in terms of his knowledge of the facts of what has been done on behalf of the petitioner. I have no doubt about that. In respect of paragraph 25, in respect of paragraph 25, and again, paragraph 25 can only be read in conjunction with the prior paragraph. In announcing the various so-called corrections and corrections of corrections, no officer or first respondent engaged in any consultative process involving petitioner or his accredited agents, nor did Mrs. Jean Adukwe-Mensah, returning officer for the presidential election, or first respondent, notify petitioner or his agents that there was a reasonable basis to revise the figures as to the votes he, petitioner, and or second respondent obtained, much less give them an opportunity to observe or participate in the processes by which those revisions were purportedly effected. That is 24, to which no objection is raised. Then in 25, it goes on, this, referring back to what has just gone on, this was clearly contrary to the responsibilities the chairperson of the first respondent and first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal, unquote. In fact, the ever-changing figures put out in the unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed the determination on the part of Mrs. Jean Adukwe-Mensah as returning officer for the presidential election and certain official or first respondent to have second respondent installed as president of Ghana on 7th January 2021 by hook or by crook. Now, my lords, in the pleadings, in paragraph 33, my lords, in fact, if I may start actually from paragraph 20 of the pleadings. I may even start from 19, because in 19 is the statement, first respondent and his chairperson, Mrs. Jean Adukwe-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Paragraph 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Jean Adukwe-Mensah, acted in flagrant violation of the 1992 Constitution.
Mr. Chikata,
yes.
Could you hurry to where it is your pleading that she intended to install the second respondent by hook or crook, or where this evidence takes its roots from?
In paragraph 21, we say that she was required to act fairly, reasonably, candidly, and not arbitrarily or capriciously. And then we go on in paragraph 24. We go on to point out that she was required not to be biased either by resentment, prejudice, or personal dislike, and also requires them to exercise discretionary power in accordance with due process of law. So we are pleading the fact that these were requirements placed on her and evidence to show that she did not comply with those requirements is certainly available on the basis of those pleadings. And as I indicated, in relation to the law, you then go on to draw the conclusion or to conjecture that she was determined to declare the second respondent as president by hook or crook. My lord, that is just my lord, that's not a conjecture. That's not a conjecture. If they want further and better particulars of it, of course they're entitled to ask for further, but it is not a conjecture. And we are saying that these are matters that are demonstrated in the various pieces of evidence, especially relating to ever-changing numbers on the website that will obviously be before you. And in fact, most of these are not denied. It's not denied that there were changes and ever-changing figures. It's not denied that, you know, what is in the answer, the figures in the answer are different from every other figure that we've seen in these proceedings. Now, my lord, we are saying that all this is evidence of a predetermined agenda. That is, you know, my lords, in proving facts, in proving...
This is really what I wanted you to show, that the statement or the pleading that there was a predetermined agenda to end in a particular way. That's what I'm trying to find from your...
That is a necessary implication from the ever-changing figures that were supplied right up until the point of the answer. And my lord, that is a matter that circumstantial evidence is obviously permissible in proving facts. So
hold on, say. So your response is that this allegation of hook or crook is actually intended to lead us to a conclusion that is made out of inference. Is that what you're saying?
It's based out of the circumstantial evidence, the compelling circumstantial evidence.
It's an inference. It's an inference that you are making, and you know, inferences are alien.
Yes,
in evidence, you can be an address, but not evidence.
Yes, my lords, I said we are giving circumstantial evidence on the basis of which conclusions.
What you are describing as circumstantial evidence is an inference. You are making an inference. And evidence, we don't do inferences.
My lord,
you can address on it.
My lord, these are not inferences. We are saying there was a predetermined agenda, and we are saying that that predetermined agenda is evident from the ever-changing circumstances and from the refusal to act in accordance with the responsibilities to be fair and candid. We say in paragraph 22 that she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. We say in paragraph 23 that prior to her making the said purported declaration, Mrs. Jinadukwe Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of these concerns. My lord, if evidence cannot be given in relation to all these matters and how they lead to the inevitable conclusion of a predetermined agenda, then respectfully, I don't know what else we're supposed to do in terms of providing evidence. We go on. My lords, I'm not finished. We go on in paragraph 30. In paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. My Lord, I mean, one should, with respect, I mean, take cognizance of the various elements of our paragraphs in the pleadings. The fact that there's no explanation, there's a total lack of transparency, these are all things that have been pleaded. And if evidence is being led in terms of the predetermined agenda and the determination by hook or by crook to arrive at a certain result, I cannot see how that evidence can be regarded as objectionable in any way. They can cross-examine on that evidence. They can seek to discredit him and say that he has no basis and whatever. But we cannot say that that evidence is not admissible. Now, my lords, I believe the next paragraph was paragraph 26. The Gazette notice is required to be based on the declaration actually made by Mrs. Jean Adukwe-Mensah as the chairperson of the first respondent. I'm sorry, that's our pleading. 26 of the witness statement. Yes. The 26 of the witness statement is where the chairperson of first respondent and first respondent are also not required under Article 296 of the Constitution to be biased either by resentment, prejudice, or personal dislike in exercising any discretionary power. They're required to exercise that power in accordance with due process of law. The chairperson of first respondent, Mrs. Jean Adukwe-Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Mrs. Jean Adukwe-Mensah, has a close familial relationship. Mrs. Mensah was thus at all times, at all material times in the conduct of her responsibilities, biased by prejudice in favor of the second respondent. Now, my lords, we have again pleaded the requirement of compliance with Article 296B. And in turn, in their answer, paragraph 39, paragraph 40 of their answer. In further denial of the petitioner's claims, first defendant says that it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. So there's a denial of our allegation. There's a denial of that, and therefore a witness that is speak she actually goes on in paragraph. The answer goes on in paragraph 41 to talk about, in a bid to enhance transparency and public participation, it took certain steps. So, my lord, clearly the answer of the first respondent shows her recognition that the issue of her bias is part of what has been pleaded. And she is asserting in paragraph 40 that she did a first respondent, well, in fact, respectfully, that paragraph just says the first respondent. It doesn't speak specifically about her. So we should take the words as they are. The first respondent says it's complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election, with fairness to every candidate and without malice, ill will, or bias. So clearly there is an issue that is before this court of whether there is bias to anyone or in favor of anyone or not. There is an issue.
So, Mr. Secretary, where in your pleadings did you plead that there's bias because the first respondent, in a way, is related to the wife of the second respondent? Where?
My lords, we plead the 296B, bias by either by resentment, prejudice, or personal dislike.
Honestly, by the use of pleadings, we don't plead law. We don't. 296 is a constitutional provision.
Yes, my lord, we plead law in the context where certain facts related to the operation of that law are being contested, because we have to state that the Constitution has this requirement in order to point out that that requirement has not.
But then they went further, as you rightly pointed out in, I think, was it paragraph 40? Yes. And then they pleaded in answer that they complied with the law and that they were not biased, and they went through with the due process as required by law.
So
yes, but then if you go further and we are concerned with the last paragraph of paragraph 26. We are not comfortable with it.
That is their problem.
That is their problem.
The paragraph starting from the chairperson of the first respondent, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of the second respondent, who appointed her in August 2018.
Yeah, that is
and with whose wife, Mrs. Jane Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was thus, at all material terms in the conduct of her responsibility, biased by prejudice in favor of the second respondent and against the petitioner. They are saying that this has not been pleaded, this fact, this evidence is not based on the pleadings.
We are saying respectfully that what is contained in the witness statement is evidence of the pleading of non-compliance with Article 296B, because that is part of our case. But
you must plead before. I mean, the thing does not even appear in your pleadings. So how can it turn to become evidence? The thing does not appear in your pleading. We have not read anything like this from your pleadings, from the petition.
Don't you think the close familiar relationship should be a material fact that based on Order 11, Rule 7, you should include in your pleadings?
My lords, I am not of the view that by itself is a material fact that should be reflected. And my lord, let me be clear. Bias could be related to a number of different factors. A close familiar relationship is a potential element. And if, in spite of the close familiar relationship, there is action taken that reflects due process, transparency, and everything, then in that situation, the close familial relationship would not affect the conduct of the proceeding. So it is really a matter of evidence whether in the context, in the circumstances that we're dealing with here, whether we have a situation in which that familial relationship has actually affected the conduct of the responsibility. That is a matter of evidence.
How does she respond to this? This is your evidence.
To that.
This was not in your pleadings. This was not in your pleadings. Are you not taking her by surprise?
Well, we don't believe that this takes her by surprise, because this, I'm sure, is legally. There are facts that are very well known to her. In fact, there are facts that are.
But we don't know. Well, we're sitting here, we don't know. Until we read this, we didn't know.
Okay.
Okay.
My lords, we are saying that in respect of paragraph 26.
Can I find
I'm concluding my response on paragraph 26. Am I allowed to do that? We're saying that in response to paragraph 26, these allegations of bias are sufficiently referenced in our pleadings in relation to the operation of Article 296B. And we're saying that the denial that is contained in paragraph 40, that denial indicates that the petitioner is not taking the first respondent by surprise in respect of the allegations of bias that are in the witness statement. Now that was in paragraph 28. I understand that the objection is to a portion of that paragraph, and if your lordships could clarify which portion. Yes, the secrecy and lack of transparency regarding the figures thrown up by one or more officials or first respondents seeking to justify after the event, Mrs. Jenadikwe Mensah's 9th December 2020 purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration and shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast. My lords, I have referred already to our pleadings in respect of transparency, and I have also referred to our pleadings in respect of these changing figures. And if I may go over that again for the purposes of this response. And we start from paragraph 8. The claim that the percentage of votes cast, votes obtained, paragraph 8 of the amended petition. With the claim that the percentage of votes obtained by second respondent was 51.595 of the total valid votes that she herself distinctly stated to have been 13,434,574 was a manifest error, as votes cast for second respondent would amount to 50.098 and not the 51.595% erroneously declared. And then in paragraph 12, which I referred to before, we indicate that if the total number of votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 113,121,111, a figure that is completely missing from the purported declaration by Mrs. Jenadikwe Mensah on 9th December 2020 and the purported rectification on 10th December. So we have already intimated these initial changes. And then we proceed, as I indicated previously, we proceed to make reference to the fact that this is in paragraph 22, which I referred to before. Mrs. Jean Adukwe-Mensah, predetermined prior to the 7th December 2020 presidential and parliamentary elections, that she would announce the results within 24 hours after the close of polls. Consequently, she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. Prior to her making the said purported declaration, Mrs. Jean Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of those concerns, and the letter is attached. And then we also further indicate the lack of transparency that was involved in the purported corrective press release. And this we do in paragraph 30, in seeking to justify the new figures put forward in the press release. Various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. There's a direct reference to the lack of transparency in that paragraph. And we go on further in paragraph 31 to say that the so-called rectification of the errors in the purported declaration was itself egregiously wrong, and we go on to provide. So, my lords, in paragraph 33, if Mrs. Jean Adukwe-Mensah, as returning officer of the presidential election, had determined in good faith that her declaration on 9th December 2020 was in error, her constitutional duty to be fair and candid, and my lord, that explains why we had reference to the constitutional duty in the pleadings. That her constitutional duty was to be fair and candid required her, among other things, to acknowledge the error, set aside her erroneous declaration, and proceed on the path to correcting her error, respecting the rights of candidates to participate in the processes towards the making of such a declaration. So we indicate what transparency required. We didn't just say lack of transparency at large. And we go on in paragraph 34 to say that the unsigned press release of first respondent has no value in the determination of the validity of the declaration that Mrs. Jean Adukwe-Mensah made on 9th December 2020, especially as the issue of the release was not undertaken transparently and in accordance with due process of law and established practice, including the participation of affected candidates through their respective agents. So we have pleaded everything that we need as a foundation for pointing out that what was done secretly, in the sense that it was done, without reference to any of these candidates, completely by themselves, and not in accordance with the legal requirements for the participation of agents of the candidates. I mean, all these paragraphs that I've adverted to are specific in reference to lack of transparency, lack of contact, consultation with anybody. And my lords, I mean, I cannot see how the witnesses' indication that the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondents seeking to justify after the event Mrs. Jean Adukwe-Mensah's 9th December purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various elections, so for the various candidates. So, my lord, the point we are making is that there has been sufficient basis laid in the pleadings for there to be evidence that shows that figures were just being cooked, because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted, and collated, which is what it should be. So, my Lord, respectfully, we would submit that there is a basis in our pleadings about lack of transparency, lack of due process, in respect of paragraph 30, and if your lordships could again perhaps read out what the ground, the specific ground is, so that...
Are you asking for help with paragraph 30?
Yes.
30, the whole of the paragraph.
Yeah.
On the basis that...
Yeah.
On the basis that the witness cannot speak to the legal validity of the legislation referred to, that is CI
127.
Okay, my lords, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondent, CI 127, it now interposed between the strong room and the constituency collation centers without any good reason another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of votes, of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided. In the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 petition, the petitioner did not come to court saying that annul 4 million votes of voters who have voted. Annul them because in some cases pink sheets didn't have presiding officer signature, or there were duplicate serial numbers. That, in the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Chikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
the testimony of the witness is that the interposition,
the new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection is, the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And yes, that is a complaint.
It was subsidiary legislation made by the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, but you can operate a legal provision in a manner that leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not lead to the results.
And so, once again, you are inviting us to make an inference, or what?
My lords, I'm not inviting just making an inference. I'm saying that we have pleaded a lack of transparency. We have pleaded a lack of consultation in respect of how these figures popped up. And the witness statement is showing one of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Chikat, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
No, now, those numbers is such a big issue that if that is your case. It should be in the petition that A, B, C, D, from this polling station to this constituency to this regional collation center, these figures changed. There's nothing about this in the petition.
My lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
the petitioner. May I answer you? The petitioner is challenging, firstly, on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibility the way you did. That is a basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. That the petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
my lords,
statement.
with respect, counsel has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timeously erased. Yeah, so that, yes, you don't disrupt.
My lord, I thought I was actually raising it timelessly.
My lords, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from those figures. And we're saying that after, we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you are supposed to be speaking to paragraph 30, which is about the original collation. And the question from my brother on my right was that There is nothing in your pleadings about the collation process.
My lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through these 4 stages, and so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis the witness is entitled, because my lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness
but by paragraph 30 of the witness statement, the witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that regional collation center.
My lord, you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections, the conduct of the election. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes now strong room to constituency collation. That's what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we're saying that that is not the objective. But CI 127 has to be executed. And if the petitioner, in making this interposition without good reason, if the petitioner has, as a result, had problems in the collation, which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outline in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
No, Mr. Chikita, we don't want you to read that one. We are familiar with that.
So, my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that? My lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if he were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him? I could.
You could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Chikata, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame. B-L-A-M-E.
But
blame.
My lord,
is it Parliament or the first respondent or the structure that was
my lord, frankly, Parliament has nothing to do with this.
Yeah, because what he did...
Parliament has nothing to do with it, because this is subsidiary legislation.
But it was laid before Parliament.
Yes, but I mean, my lord...
It was laid before Parliament for 21 days.
My lords, anyway, my lords, I believe that is really not the essence of... Because, it
totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation laid before them?
The testimony.
Please.
The testimony, as far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we're saying that the implementation of the law is what occasioned the problems. And that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then, in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
You don't have to violate a law in order to implement it in a way that occasions...
If you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of a law or of a statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problems. In paragraph 32, indeed, aggregating the votes. Yes, my lords, aggregating the total valid votes as shown by the 275 summary sheet released by the first respondent on his website, the resultant figure is actually 13,200, which is different from the 9. I mean, my lords, how can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she herself, or figures that her first respondent has put forward as a correction of other figures that she read, which we all heard. She's put forward those figures. And here, and then subsequent to that, there is published on the website, 275 constituencies. And we do our arithmetic and we say that those figures actually result in this, not in the figure of the purported correction. How could that possibly not be, you know, I mean, a piece of material evidence from a witness in this election petition, aggregating the total figures. And my lords, this comes directly following paragraph 31 after the 7th December 2020 presidential election. Petitioners, paragraph 31 of the witness statement, petitioners' representatives in the strong room discovered that there were errors as a result of which they did not certify the summary of the results from some of the regions. They also noticed anomalies with some of the collation sheets that may have been inputted into the results. Based on the observations, the NDC calls a letter and so on. And then indeed, and it follows by talking about what what the first respondent put on the website, which is in contradiction to what she purported to be the correct figures. I mean, my lords, and what is more, those figures are different from
really, they are not making any case against paragraph 31. Yeah.
Yes, but paragraph 32.
It's 32.
But paragraph 32,
they are not quarreling with
paragraph
31.
32 is stating quite clearly that the figures that were published by the first respondent on their website, when you put them together, and this again is a matter relevant to the different figures that were being offered by way of correction on the 10th and later. So I think this is a very material, you know, every piece of evidence, especially, my lords, when it is acknowledged that the witness can have put to him the case of the first respondent. The case of the first respondent is that an inadvertent error was made and it was corrected. And the correction itself was subsequently corrected. And we're saying that when you take what is on their own website, this is effectively in the nature of an admission by them that they were wrong even in their purported correction. This is a clearly material piece of evidence. And in paragraph 33, which is the last, I think the last but one, again, this is a statement of that point, that the aggregated figures, the aggregated figure from the total valid votes as shown by the 275 summary sheets released by first respondent on his website. This figure is also different from the corrected figure of 10th December in the unsigned press release. So paragraph 32 makes reference to the figures on the website, and then paragraph 33 says that that was also different from the corrected figures. And my lords, with the greatest respect, the issue that is at stake in this petition is the conduct of the first respondent as the returning officer of the presidential election. And that conduct...
Mr. Chikata, which relief relates to the conduct? If we look, which relief? For settlement. You're seeking declaration.
The issue that we've put down, the relief that we have put down is a relief. We have put down a number of reliefs. Now, relief A is that the chairperson was in breach of Article 63(2). Relief B, a declaration are based on the data in the declaration made, the data contained in the declaration made by Mrs. Jean Adikwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7 December. No candidate satisfied the requirement of Article 63. The third relief is a declaration that the purported declaration made on 9th December of the results of the presidential election by Mrs. Jean Adikwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7 December is unconstitutional, null and void, and of no effect whatsoever. Now, I mean, we have set out in the preceding pleadings the basis of our claim of unconstitutionality. We've set them out, including the failures in respect of Article 23 and the failures in respect of Article 296. We've set them out. And we're saying that a declaration that is unconstitutional should be made. And in paragraphs 32 to 33 of the witness statement, we are responding, as we're entitled to, we're responding to the case that the first respondent is putting forward, in which she puts forward certain numbers, and we are relating those numbers to what she herself had, or what the first respondent had put on their website. And with the greatest respect, that is clearly a relevant matter. Now, my lords, I have to say that, I mean, these attempts to, take out of our witness statement extremely material matters that relate to the case that is being presented by the first respondent, I mean, are really matters that we consider, really very, very seriously, because we cannot see how anyone can objectively claim that these changing figures that we have been talking about as part of the lack of transparency and so on cannot be accepted as part of the witness's witness. Paragraph 37, this conduct of certain officials, and maybe, again, my lords, paragraph 37 cannot be read in isolation of the previous paragraph, because when it says this conduct, the meaning of this conduct cannot be read without going back to 36. In 36, because 36 says, Exhibit F is a spreadsheet covering sample details from 26 constituencies showing vote padding by certain officials of first respondent in favor of second respondent. When the votes second respondent obtained in all polling stations are shown on their respective pink sheets in these 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. They show that more votes were added to those of second respondent than he had in fact obtained. So this is a conduct that is then referred to at the beginning of 37. This conduct of certain officials of first respondent in padding the votes of first respondent is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers, with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of first respondent to have second respondent unconstitutionally and unlawfully installed as president of Ghana. So this again is evidence that concludes paragraph 36, and paragraph 36 is not being objected to, and it concludes paragraph 36 and indicates that this conduct that is referred to is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers. And my lords, whether indeed numbers were being manufactured or not is obviously a question of fact. It's an issue that is to be resolved by the evidence of the parties and by the determination of which evidence is worthy of acceptance as truthful evidence. And therefore we submit that none of these passages of evidence can be considered as passages that cannot be legitimately within the witness statement of our witness.
With the leave of your lordships, we wish to refer to Order 11 to reply. Yes. Yeah. May I have the lead of the court to reply? My lords, I wish to refer to Order 11, Rule 12.1 of CI 47, which reads, and I quote, subject to sub-rule 2, every pleading shall contain the necessary particulars of any claim, defense, or other matter pleaded, including, but without prejudice to the generality of the foregoing words. A. Particulars of any misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. And B. Where a party pleading alleges any condition of the mind of any person, whether of any disorder or disability of mind, or malice, or any malice, fraudulent intention, or other condition of the mind, and except knowledge of particulars of fact on which the party relies. My Lord,
Mr. Akutuampa, what you've just read is for the practice and procedure in the High Courts.
Yes.
Yes, and that's not what is before us is not pleadings properly so called. Yes. This is an election petition.
Yes.
And it's regulated by rules and other things. So we have made it clear that we are not applying the High Court Civil Procedure rules in this case. We are applying the Evidence Act to regulate the taking and admissibility of evidence in this case. So allow us to regulate the procedure, because this is an election petition, because it appears it's something new. So the lawyers keep on referring us to the High Court Civil Procedure rules and other things. But this is a peculiar jurisdiction which we are exercising.
My Lord, my understanding is that these rules may provide guidance to the court, and it is part of our legal practice, but where a party alleges matters relating to a state of mind, like predetermined mind and prejudice and so on, he must give particulars in his petition. The petitioner never gave the particulars relating to the alleged predetermined intention, the bias, and so on. None of these matters, particulars, have been pleaded. And we would urge, based on that and all the other things we have submitted to this Honorable Court, that the pleadings, the evidence, the paragraphs in the evidence, many of which are actually material facts which ought to have been pleaded, should not be admitted. We pray accordingly.
Respectfully seek your permission, because a point of law, a new point of law has been raised. Because as the law is in our bosom. That well, very well.
Yeah. All rise.
Atre Fami Kojo B 2020 the Mahameba and the Mukele cause offer. I go for Dubai and we're share 4 years, but now so then we'll be here. 1 district, 1 foot, scan the bar, watch a man family. And penny a bar said 2020, but soon a team crumb. Abanadi Mahamafa, Namafa, Mahamafa, Namafa, Mahamafa, Namafa, 2020, when you will be on precost, Mahamafa, Namafa, Mahamafa, Abanadi Mahamafa, Namafa, 2020, when you will be on pre. Galamse was so Bessamokina, or by no cofa soldiers. Was the intervention? What is this cavitas? Now, what's a sea low bed? Ubegunu, Telebetu, Benyabro, I'm a need to. A pen of a partner said 2020, but soon yet Tim Crumb, Abanadia Mahamafa, 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 2020, when you will be on precost, Mahamafa, 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 Abanadia Mahamafa, Mahamafa, 2020, when you will be on pre. Or buy new Obegu banks. I didn't say the kind of crime went yes. I will bet my arm and I nice. My Mukululu, Namashasi, Pasiasha and Tiasun Prilu. More better now, so the Moya and Yahu. Ahoya, and you bring 2020 lesson, Yamaha chance. Mahamafa, 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 2020, when you will be
even more than 2 hours, I would say. And today's proceedings actually started at 10. And then the first witness with the petitioner, as already outlined, is Johnson Asidun Ketia, who is the General Secretary of the NDC, and he went into the witness box taking the oath and all that. Then the second respondent raised certain objections. In the witness statement, they have about 42 paragraphs coming from the petitioner's side, 42 paragraphs of which Johnson Asidun Ketia is witnessing to the entire petition filed by former President John Dramani Mahama. And the second respondent raised objections to about 10 of these 42 paragraph statements. And well, we had arguments coming from both sides. And finally, the justices have just recessed to take a final conclusion on these objections. We will move to join our lawyer for us to have, again, an understanding of exactly what has happened in court, the various legal explanations that he will provide for us. So, Dr. Kwekwajiman Budis, join us back on Zoom. Doc, good afternoon, and thanks again for joining us.
Good afternoon. Thank you for having me again.
Let me just get your initial thoughts, what you make of the entire process that just happened in court.
What I make of what?
The entire process, what just happened in court, your initial thoughts on that, then we can move into specifics.
So we saw that the petitioner was ready, as was directed yesterday, that hearing will begin today. And we know that the petitioner has filed 2 witness statements. So the first thing that the petitioner sought to do was to call their witness, and that's in the person of the General Secretary of the NDC. And they wanted to essentially, in simple terms, wanted the court to adopt their witness statement as the testimony of that particular witness, but saw that the respondents raised certain objections in relation to specific paragraphs in the witness statements, and there were other or there were reasons that were assigned to these, and so that's what ensued the whole back and forth in terms of the content of the witness statement. That was what transpired until the Supreme Court decided to rise to consider all the arguments that have been made in relation to that. So everything that has gone on has to do with the witness statement of the petitioner's witness, first witness, that they wanted the court to adopt as the testimony of that particular witness, so that we can move on with the process. So that's what has been transpiring, or has transpired before the court so far. All
right, I noticed 3 things, so if you can help us understand this. The first one has got to do with the witness statement. The second one has got to do with pleadings.
The volume is quite low, so I can't hear what you're saying properly.
Is it better now?
A little bit, the noise in the background, but I'm trying to hear what you're saying.
Okay, I'll just hope that we're working on that bit of it. Is it better now, Doc?
Yes, it's okay.
Okay, I said I noticed 3 things, so if you can help us understand these areas. Witness statements, pleadings, and evidence, and whether there's any bit of intertwining in all these three areas.
If I get you right, you're trying to get an understanding of what these mean. What does the witness statement mean?
Yes, the evidence.
When we say pleading, what does it mean?
Yes, and the evidence, and whether there is any and whether there's any link that cuts through the three of them. Whether there's a link between the three.
Okay. So what I can say is a witness statement, as the name itself suggests, is the statement of a witness, which sometimes may be given in lieu of the actual testimony of the witness. Is what the witness is testifying to. So if it can be adopted in certain types of proceedings, the parties are directed to file their respective witness statements so that the proceedings can go on quicker and it can be expedited and things of that sort. So that's in a nutshell what a witness statement is. When we talk about pleadings essentially are reference to the facts that the parties are making or alleging in support of whatever claim or defense they are putting up. So for instance, if you bring a suit against another party, the first things, or one of the very first things that you do is to file your pleading. So in an ordinary civil case or in civil procedure generally, the plaintiff will file his statement of claim. When you issue the writ, it will be accompanied by a statement of claim. And the statement of claim is where is that which contains the pleadings, and the pleadings are the specific statements of facts that you are putting forth in support of your specific positions. So, for instance, pleadings are the plaintiff is so and so. The plaintiff resides here. The defendant, that's in a civil proceeding, the defendant is Mr. So and so. The defendant is the managing director of so and so. On this day, the defendant did this. So it's simply the fact that you're putting forward to narrate your side of the story, or to put forth your claim, or to back the claim that you're making for whatever reliefs that you seek in the court. So once that is done, the other party, the defendant in a civil case, will also have the opportunity to file their statement of defense, for instance, where they will either accept or acknowledge the truth or otherwise of some of the statements that you're making. For instance, if in the plaintiff's statement of case, statement of he suggests that the defendant is called Kwesi Asumesi. The defendant, in his statement of defense, in reply to the statement of claim, will can accept that I admit paragraph 1 of the plaintiff's statement of claim, which says my name is Asumesi. Those kinds of things will not necessarily be in controversy, but he could generally traverse most the statements that are being made, except where he specifically decides to admit certain paragraphs, the statement of claim and those kinds of things. So that's what pleadings are about. Pleadings are those statements that you make in support of the case that you're making, or to defend it, we may put it that way. Once some statements of facts have been made that allege certain things that you, the other side, feel like you need to respond to, and things of that sort. But there's a fundamental rule in civil procedure, civil proceedings also, that suggests that it is facts that are pleaded and not evidence. So in your pleadings, you're supposed to plead facts, the material facts that you feel will make your point or will make your case in the way and manner in which you deem fit for the purposes of the reliefs that you seek. So you're not supposed to plead evidence, and that's what we saw transpire. We saw some back and forth between the justices and counsel for the parties involved in relation to when evidence is being pleaded, or whether or not evidence is being pleaded, as opposed to the facts being pleaded and things of that sort. So it's the facts that you plead. And so evidence, on the other hand, are those documentary or oral sort of, for want of a better word, evidence that you will proffer in support of your case. So if you've alleged in your pleadings that maybe so and so did this on so and so date, then you may have some evidence that you may want to introduce that goes to buttress that particular pleading or that particular point that you made, that indeed this happened on this particular date. So those are the explanations in terms of the differences, what we mean by witness statement, what we mean by pleadings, and the fact that you need to plead facts and not evidence, and that's what evidence also means. Evidence are the things that you would use to buttress the point that you're making, so that you're able to get determination or a ruling on that particular matter in order to get the relief that you're seeking from the court. So in simple terms, that's what we mean by all these things.
All right, is the pleadings the same as petition, as the petition?
So, like I was saying, in an ordinary civil case, say if we have to do with a land dispute or a contract dispute or whatever, it is the pleadings would be the statement of claim and the statement of defense and things of that sort. That would be what we refer to as the pleadings. In this particular instance of the election petition, the pleadings are contained in the initial petition that the petitioner filed on 30th December, setting out various facts in their view that point to the fact that the validity of the election was in question. And then the respective answers of the respondents as well will also form part of the pleadings in this particular instance. So what the petitioner said in their petition in the initial instance, as well as the responses contained in the answers of the two respondents, are what will be considered the pleadings in this particular situation or context of the election petition.
And help us to understand when it comes to getting the witness statement and the role that the pleadings is supposed to play in addressing in the witness statement.
I don't quite understand the question.
We realize that the first respondents raised objections in the witness statement of the petitioner. And then the arguments, one of the arguments is that they have not pleaded for that. So they don't see the need for it to actually appear in the witness statement. So we're looking at the pleadings and the role it plays in having a witness statement, or putting together a witness statement.
So generally speaking, you need to, when you bring in, let's say if you are the one bringing the case, in the case of a petitioner or a plaintiff or whatever the case may be, you are the one alleging that something has been done or hasn't been done and seeking some particular reliefs. And so according to the rules of civil procedure generally, you're supposed to plead the material facts that in your view will help you make your case. That's the whole point. You are bringing the action, so you need to make your case, and you need to plead those material facts that will make your case. So if pleadings have closed and you are not allowed under the rules, for instance, to amend those pleadings, or the time for amending those pleadings have passed or have lapsed, you cannot subsequently in your testimony, for instance, or through your witness statement, sought to or seek to introduce new areas or new facts, or sought to present evidence to sort of create or lead to a particular point that you, or buttress a point that you have not necessarily raised in your pleadings. So that's what was happening, and that's what the whole exchange was about. And we're not going into that. We're just saying that generally speaking, if you have filed your pleadings have closed and all that, you cannot necessarily introduce new facts and seek to present evidence to buttress or to make those facts quite clear or convince the court of that particular fact when it was not necessarily introduced in your initial pleadings, and the time for filing pleadings have closed and things of that sort. So that's what it is. So
it means that your pleadings, and again, we are not referring to what's happening though, but on a general term, it means that your pleadings should be addressed specifically. That's what it means.
Oh yes, so I mean, you are the one saying, for instance, that the land belongs to you, or someone has breached a particular contract and things of that sort. So you need to, in your pleadings, set out specifically the facts that lead you to that belief that indeed the contract has been breached, or indeed the land belongs to you and the person has encroached upon the land unlawfully and things of that sort. So that if there are some facts that you do not necessarily plead to or make clear in your pleadings, you cannot necessarily subsequently, when you are putting forth evidence to buttress your pleadings or the facts that you've alleged, to make your case generally, you cannot, for want of a better phrase or word, try to sneak in new facts that you have not necessarily pleaded in your pleadings. It won't generally be allowed in that regard. So you can't introduce evidence to make the case on the points that you haven't even raised earlier on. That seems to be the position, and that seems to be the crux of what was happening not too long ago.
Right. So what if in buttressing my point, I seek to introduce other things that actually will buttress my point? That's also not allowed.
So if the facts haven't been pleaded, and so it will be incumbent on you to convince the court that indeed you pleaded those facts, so as you will be allowed to lead evidence in relation to those particular facts. But to the extent that certain material facts have not been pleaded, and maybe the time for pleadings have closed and there isn't an opportunity, for instance, to amend your pleadings. And we remember that in an election petition, there are certain amendments are not allowed, which, for instance, will alter the grounds of the petition, for instance. And in relation to the respondents, amendments are not allowed that will also seek to alter the response that is provided to the petition in relation to the answer that the respondents give.
All right, now, and moving on, the justices are recessed now. They'll return to decide on the objections raised. Are they going to handle each objection, 10 of them, or they're just going to deal with the entire 10 and just rule on just that, give a single ruling, or they will give in 10 rulings on it?
I can't comment on exactly what the justices are going to do and what they will do. You know, we can't comment on that.
I get that, though, but just an understanding of how. I get it, but just an understanding of how the ruling, not specifically going into the ruling itself, but they've raised about 10 objections out of 42. Yes, just go on.
In relation to the objections that have been specifically raised, we realize that even counsel for the petitioner was struggling to follow in terms of the specific objections that were made in terms of specific paragraphs in the witness statement, and he had to be assisted by the court and all that. As to what the court will do as in taking them, the objections one by one, and then we'll have to wait to see how they deal with them. But obviously, the objections we're taking in relation to different paragraphs of the statement of case of the first witness of the petitioner. So generally speaking, it would seem as though, and you saw that there were arguments that were proffered on behalf of the petitioner in relation to those specific objections that were raised by the respondent. So to the extent that they were different objections based on different paragraphs in the witness statement, the court will make a determination on them one way or the other.
And again, not referring to this case in particular, but help us to understand what the processes will be like. If the objections are sustained, what does it mean? If it's overruled, what does it mean?
Assuming you raise an objection to testimony that is being given by one party in the case and it is overruled, if the objection is overruled, it means that that part or portion of the testimony simply stands. If it is sustained, it simply means that that part or portion of the testimony of the witness, whoever it is, as the case may be, is expunged from the record and has no place within the records and will not play a part in the determination of the matter at the end of the day. That's what it simply means.
Right, and it means that if it's sustained, it cannot be referred to again till the case ends.
Yeah, that's generally what testimony is. If you're proffering testimony that is not permissible, is objected to on whatever grounds, and it is sustained, it means you can't raise that anymore. It's not permissible. It's not allowed for the entirety of the proceedings.
And that means that after this, then we can, Justice Civic might go through the further cross-examination.
It's possible that that's what we would see at some point in time. Whether it's going to happen today or not, nobody can really tell. We have to wait to see how things progress, how the court comes out and rules on the particular matter that's before them right now in terms of the objections that have been raised.
Well, the statements one of the justices raised or even made when the petitioner was about to respond to the second respondent addressing his argument, and the justice said that, well, the law is in their bosom. Tell us how powerful the judges of the Supreme Court are in determining cases and how they can also interpret laws. Just briefly on that one.
The Supreme Court is the highest highest court of the land. The Constitution establishes the judiciary and there's judicial power in the Supreme Court and establishes the superior courts of judicature, with the Supreme Court at the apex. Then you have the Court of Appeal and the High Courts, as well as any other lower courts that are established. The Supreme Court is at the apex in terms of justice administration in Ghana. So, and the Supreme Court under the Constitution has original jurisdiction in interpreting and enforcing the Constitution. And so that's what kind of judicial authority and power that is vested in the Supreme Court. And obviously, the power vested in the Supreme Court is dispensed, or justice is dispensed with by the justices of the Supreme Court that are empaneled at any particular point in time to deal with any issue that comes before them. And what the Supreme Court says the law is, that is what the law is. So, for instance, in interpretation, for instance, Parliament can enact legislation that says one thing, but the Supreme Court, given that there's a live case before it, which is not necessarily moot, which touches on the validity or the act in its entirety or some parts of the act as being unconstitutional or not, the Supreme Court can interpret that particular act or provisions therein in a manner that probably wasn't what Parliament was even thinking. That is the sort of power that is given to the Supreme Court within the scheme of separation of powers. We know that the Parliament or the legislature makes laws, but they making the law doesn't mean they interpret the law. Of course, sometimes consideration can be had of the Hansard and some of the deliberations that went on in making that particular law, as well as the memorandum to the law, what probably defect that existed in the existing, what gaps existed in the law that necessitated the enactment of new legislation. But the court, ultimately, the Supreme Court, for instance, if a matter involving that particular act or provisions therein comes before it, can interpret the law in the way that they deem best in terms of giving effect to the essence of the law. And so that's why we hear modern purposive approach to interpretation, where you necessarily stick to the ordinary meaning of the words, but look at the meaning of the words within the context. If the meaning of the words in the statute, for instance, within the context is plain and clear and there's no need for further elaboration, then it stays that way. But if it would lead to some form of absurdity, for instance, if there will be some absurdity in interpreting the words to mean as they said, the plain meaning of the words, then the court will go beyond that and try to understand the purpose for which the law was enacted and give the law a purposive interpretation to achieve the overall ends of justice. And we've seen it a number of times in numerous cases that have come before the Supreme Court, where the court has adopted the modern purposive approach to interpretation and all that.
All right, just a quick one. This is my final question, then we can wrap up with you whilst we wait for the justices. We'll take our viewers back to the Supreme Court to join my colleague Abdul Haimun. But just my final question. You said that what the Supreme Court said the law is what the law is. So does it actually matter if a lawyer goes to the Supreme Court to argue his or her case out?
Of course it matters. I mean, it's incumbent on you to persuade the court on your position. So that's why sometimes there's mandatory authority, there's persuasive authority, and all those things. You're making your case that on the basis of the law, on the basis of precedent and all that, you believe that this is the position of the law. And if that is the position of the law, then your claims need to be validated, for instance, or the relief that you're seeking ought to be granted. It's the opponent or the person, the other party on the other side will also have their arguments, will also make their argument that we rather believe that this is the position of the law, this is what we feel the law says and means, and so the court should accept our arguments in support. And obviously, when you're not making the arguments in a vacuum that I believe or you think that the law has to be this way, so it should be that way. No, it has to be grounded in authority. It has to be grounded in case law, for instance. You need to point to statutory provisions or constitutional provisions and then make arguments by trying to persuade the court in terms of your perspective or your opinion, but it still has to be grounded in law. So at the end of the day, the courts will, on the basis of everything that is before them, on the basis of all the arguments that the various parties are making, come to a conclusion or a determination that indeed this is what the law says and this is what the law is. And the Supreme Court being the final arbiter of all disputes within our territorial jurisdiction and being the highest court of the land, the court, once it decides, once it gives its judgment, that is what the law says. It doesn't matter that individual parliamentarians or parliament as a whole felt that they wanted to achieve this particular end. But the court, if it, for instance, adopts a purposive approach to interpretation, they can interpret the law to achieve the purpose for which they believe the law was enacted. And that is the essence of separation of powers. That is the essence of having government and giving each its power or its realm within which it operates.
All right, well, we'll leave it here and we'll get back to you. I'll take our viewers back to the Supreme Court, not into the court, but to join Abdul Haimun to pick other reports from there. Stay with us. Over to Abdul Haimun.
Led by the lead counsel for the petitioner, Mr. Chacho Chikata, to present his witness statement. Soon after presenting the witness statement, even before any question could be directed at Mr. Johnson Esiedun Ketia, the lead counsel for the second respondent, Mr. Akoto Ampao, rose to raise some objections to portions of the witness statement as was presented by Mr. Johnson Esiedun Ketia. Some of these included paragraphs 6 and 7, which Mr. Akoto Ampao said were completely out of place in the evidence in chief. And then he also talked about portions of paragraph 25 of the witness statement, asking that it also be struck out from that statement. He spoke about paragraph 26, which also referred to some familial relationship between the second respondent's wife and the chairperson of the EC, among others. And basically that has been what has been going on in court since morning, because counsel for the petitioner, Mr. Chachuchikata, also rose to make his points and give evidence as to the fact that these matters that Mr. Akoto-Ampao wanted to be struck out of the witness statement, because according to him these were completely out of place, were indeed tendered long ago in the petition itself, and therefore should be made to stay. The court has risen to consider these matters. So we can report to you that Mr. Johnson Esedun Ketia, the witness for the petitioner, is in the box, but he's yet to respond to any questions this morning, because some issues regarding paragraphs in the witness statements have yet to be resolved. My colleague, who has been sitting in the courtroom throughout the morning, is here with me, Edward Nyakon. So, Edward, thank you very much. We've seen that Mr. Johnson Esedun Ketia was invited into the witness box. He indeed present his statement. Soon after that, Mr. Akoto-Ampao rose to raise objections to portions of the witness statement. Indeed, the judges asked him why he would not wait and do that during cross-examination, and his response was that it might be used against them later in the process if they do not raise the objections at the time that they did. You sat in court. Exactly what happened?
Yes, the issue referred to Mr. Akoto-Ampao, if my memory serves me right, he cited Hammond and Odoi case 1982, 1983 in the Ghana law book to justify the reason why he stood up to object to some of the issues raised in the witness statement, and then went on to indicate that some of the issues raised are prejudicial and duly scandalous and were not part of the pleadings of the petitioner, and therefore he's praying the court to strike it out. And so these are some of the things that, as we know, the first respondent counsel, Mr. Jasamenuvo, indicated that he associated himself with the objections raised by Mr. Akoto-Ampao. Then Mr. Chachikata, with the counsel for the petitioner, rose up and also buttressed his argument on the fact that all the things that have been raised there are very cogent and must be are admissible, because Mr. Akoto-Ampao indicated they were not admissible before the court. And so he was urging the court to also ensure that what is captured in the witness statement, Mr. Esedun Ketia, are admitted in court for the process to continue. Let's not also forget that there was some back and forth. We saw some of the argument put forward by Mr. Akoto-Ampao. The judges were asking him some of the issues raised in rules that govern high courts. And one of the judges, I remember, said that there's a new evidence act that is governing these particular proceedings. And to them, some of the judges are not privy, lawyers have not privy to that. And so they keep on going back and forth. It's been very hectic this morning and interesting. And again, we're seeing that, as I always say, our democracy is being tested. And once the brains are at work, to see to the validity or one way or the other of the elections. Let's see how it goes. But let's also not forget that some of the judges also raised issue about some of the issues in the witness statement, and they indicated that some of them were not captured in the pleadings. For instance, the collation of the figures as was captured in the witness statement. They said it was not, and then there was the issue of CI 127, which governs the process of the elections, that in the pleadings of the petitioner, they did not challenge that. But Mr. Chachikata referred to Article 296 of the Constitution, that yes, they do that, but to him there were level of biasness, fairness and transparency was not exhibited by the first respondent.
Let's focus a little on the paragraph 26, which refers to the supposed familial relationship between the chairperson of the EC and the wife of the second respondent, in this case, President Akufo-Addo. What justification did the petitioner give for including this in paragraph 26?
Yes, Mr. Chachikata, I remember very well that he talked about the biasness that was exhibited and the cooking up of figures, and said it has been demonstrated over and over that also contributed towards that. But some judges raised the issue that Mr. Kutampa said he was making an inference, and some of the judges also said he was making an inference, but he said that no, he's not making an inference, and what he's saying, it was if you look at the pleadings, the witness statement.
He said he could present facts to support that argument. Yes.
So he should be allowed to stay within the context of the witness statement of Mr. Sirin Katia. So all these things are some of the reasons why I believe that the judges have gone to their chambers, and they will soon come out and let us know what exactly are going to be admissible, or those are not going to be admissible.
All right. But again, Edward, there was that little, maybe negligible incident where during Mr. Chachuchikata's submissions, lawyer for the second respondent got up and interjected, and his submission at the point was that the counsel for the petitioner, Mr. Chachuchikata, had spent more than 20 minutes repeating the same point over and over again. Mr. Chachuchikata did not take kindly to those comments. He described it as disrespectful, and indeed the judges appeared to have supported him on that occasion.
They indicated that if one reason of objection must be the timing is very crucial. So they use the word timing. You must time it. Mr. Kutampa also said that he thought he did that, but the judges, I remember that was the Chief Justice himself, indicating that timing is very important. Other than that, you disrupt the argument of the person on the floor.
All right, we'll leave it here for now as we wait for the judges to return with their verdict. And now, so again, just to summarize it, the verdict we're waiting for is in respect of what in particular?
That is, objections has been raised against some portions. We talked about, we started with page 21, went to 5 and 6, and then came to 25, 26. And then 31. So these are the issues that have been raised. Talk about biasness, they talk about unfairness and all those things. And some of the second respondent, these issues are prejudicial and duly scandalous, and therefore should be not be entertained by the court, admissible in court. So they are going to go through that and come out to tell us what portions of the witness statement are going to be admissible, and those are not going to be admissible for proceedings to continue.
In essence, what we're waiting for at the moment is for the judges to return with their decision, the decision that will be based on whether or not they will agree to the objections raised by a lawyer for the second respondent, Mr. Akoto Ampal. We'll hand you back to the studio, and where the discussions will continue. We'll certainly return when we have more updates for you.
Abusiafo tabi adwumako yasan abawa bobo anu biem na afeedie ye
mahamafa 2020 when you be ampre share mama ye no mo se dollar adwane mo se mobile mo bete na tenase mobile dollar na yan taban watu na onenam wiase Salam okram ye super incompetent dia make ne kurefo evidence the bank na aguwe kofo na aguwe sie tinkwama abane de mahamafa 2020 when you be ampre cost mahamafa abane de mahamafa 2020 when you be ampre Kotokraba market wa ye wa ye Kenetia market no wa ye wa ye Second overhead wa ye wa ye Mahama e-blocks na man free SHS abaso abane de mahamafa 2020 when you be ampre cost mahamafa abane de mahamafa 2020 when you be abane de JMafa JMbra abane de JMafa JMbra JMbra abane de JMafa JMbra kana December abane de mahamafa 2020 when you be ampre cost mahamafa abane de mahamafa 2020 when you be ampre mahamafa abane de mahamafa 2020 when you be ampre cost mahamafa abane de mahamafa 2020 when you be ampre Setre family Kojobi
Yewu Petition Yewu Petition Yehunaman Ya mo bodudu Ghana forisu Petition Yewu John Mahama Petition Ya mo bodudu Ghana for Esu Petition John Mahama Petition Driver for Esu Banks Naragu I get the for Esu A teacher for Munaman John Mahama Petition Small scale money Importers are crying at your soon. Road contractors. John Mahama, Bejiane. Brano Bejiane. Brano Bejiane. Brano Bejiane. John Mahama, Bejiane. Brano Bejiane. Brano Bejiane. Brano Bejiane. John Mahama Bejiane. Driver for reason. Banks in Naragu. I get the for reason. A teacher for Munaman. John Mahama Bejiane. A doctor for reason. Nurse for Munaman. Soldier Jumana say. Police for reason. John Mahama Bejiane. Yewu Yewu Mumbra Bejiane. Mumbra Bejiane. Mumbra Bejiane. Yeah, more bodudu. Ghana for reason. Baby, and then. Ooh, yeah, ooh. John Mahama, baby, and then. Yeah, more bodudu. Ghana for reason. Baby, and then. Ooh, yeah, ooh. John Mahama, baby, and then. Driver for reason. Banks in Arago. I got the for reason. A teacher for Munaman. Ooh, yeah, ooh. John Mahama, baby, and small scale money. Importers are crying. At your way soon. Road contractors. Ooh, yeah, ooh. John Mahama, baby, and
Welcome back, and it's our coverage of the 2020 election petition. That's the presidential election petition. It's live on Ghana Television, that's GTV. We're also live on GBC News. We are live on radio, that's in Accra. It's Unique 95.7, and across the 16 regions of this country, the various regional and community radio stations. We're also live on Facebook, Ghana Broadcasting Corporation. The internet is gbcghanaonline.com. As of now, we're still waiting for the justices to return from their recession with the ruling on the objections raised by the second respondent with regards to the witnessed statements that have been allowed in by the first petitioner, by the petitioner himself. So the witness statement is made up of 42 paragraphs. Yes, 42 paragraphs. And the second respondent, that is lawyer Koto Ampao, who is representing the second respondent, raised objections to 10 of those paragraphs. Whilst we wait for the justices to return with the ruling on that, we'll take you through what's really in these 10 paragraphs and the issues raised. The second respondent, this lawyer, Koto Ampao, raised these objections based on two grounds. The first one is that they did not plead for it, that the petitioners did not plead for these statements that they've put in their witness statement, so there's no need of them putting it in there. And the second ground is that it is prejudicial and also scandalous. So based on these 2 points, that's how come the second respondent's lawyer, Koto Ampao, raised the objection to this 10 paragraphs out of the 42 paragraphs that is made up of the witness statement of Johnson Asidun Ketia, who is the General Secretary of the NDC. Let's go through some of these paragraphs. The first one was on paragraph 21. It says that following that the results being published by the first respondent on its website, and gives the website of the Electoral Commission, www.ec.gov.gh, become moving target, first respondent subsequently deleted the changing figures from its website. Then the second respondent moved all the way up to paragraph 6 and 7. And paragraph 6 and 7, first 6 of the witness statement, says that petitioner has accused, as calls to be filed a request to admit facts directed at the first respondent. I'm informed by the petitioner's lawyer that as at the time I am signing this witness statement, a first respondent has not responded to the request. I'm advised by counsel and verily believe that the response of first respondents or lack thereof to the request of the admitted fact is likely to require a further witnessed statement from me, and lawyers for the petitioners also applied for leave to serve interrogatories on the first respondent. The court dismissed the application, and an application for review of the second decision is currently pending, should the court allow any of such interrogatories to be served. Response provided may also be relevant evidence which may require a further witnessed statement. And if you recall, during the arguments for this one, there was quite an interesting argument coming from the second respondent's lawyer, and also another interesting one also coming from the petitioner's lawyer, which also got the justices involved in this particular two paragraphs, that is 6 and 7. We move to paragraph 25, which is one of the issues raised by the second respondent's lawyer, which is an objection to that. And paragraph 25 of the witness statement of Johnson Asiedu Nketia reads, "This was clearly contrary to the responsibilities the chairperson of the first respondent and the first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and responsibly and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress, and therefore before a court or other tribunal," unquote. In fact, the ever-changing figures put out in the unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed a determination on the part of Mrs. Jane Adukwe-Mensah as returning officer for the presidential election, and certain officials of the first respondent to have second respondent installed as president of Ghana on the 7th of January 2021 by hook or by crook. And this is an issue that the second respondent's lawyer had a problem with, specifically with this bit of it, by hook or by crook. From the 25, we move to paragraph 26, which the second respondent, in raising an objection to this, said that it is scandalous. And he said it's scandalous based on what is written. There's a chairperson of the first respondent and the first respondent are also not required under Article 296 of the Constitution to be quote, biased either by resentment, prejudice, or personal dislike, unquote, in exercising any discretionary power, but they are required to exercise such powers, quote, in accordance with due process of law, unquote. The chairperson of the first respondent, Mrs. Jane Adukwe-Mensah, allowed herself to be biased by her prejudice in favor of second respondent who appointed her in August 2018, and with whose wife Mrs. Jane Adukwe-Mensah has a close familiar relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. And again, the second respondent had issues with this bit of it, and they describe it as being very scandalous and prejudiced. Then we move to paragraph 28. Paragraph 28, another objection raised on paragraph 28, and on paragraph 28 they had issues with this part of the paragraph where it reads that the secrecy and lack of transparency regarding the figures thrown up by one or more officials of the first respondent seeking to justify after the event. Mrs. Jane Adukwe-Mensah's 9th December 2020 purported declaration undermines the whole attempt at, quote, correction, unquote, of what was indisputed an error reading declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual vote cast in the presidential election for the various candidates. That's just a paragraph 28. They raise other issues concerning paragraph 30, 32, 33, and 37. We'll quickly take you back to the Supreme Court. The justices are about taking their seat for the ruling. Stay with us. We'll be right back.
The first and second respondents have raised objections to parts of the witness statement of Mr. Johnson Edwin Ketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6, 7, 25, 26, 28, 30 and 32, 33, and 37. Both counsel based their objections to the paragraphs in the witness statement of PW1 on two grounds. A, that some of the paragraphs under attack are not based on the pleadings on record. B, some of the statements are unduly scandalous and prejudicial. It would be preferable to set out the paragraphs in the witness statement which in our view are amenable to be struck out from the witness statement. We are of the opinion that paragraphs 6 and 7 ought to be struck out as the witness, Mr. Johnson Edwin Ketia, cannot testify on the facts in the said paragraph. It would have been admissible if the petitioner is himself testifying. The statements in the said paragraphs are not within the knowledge of the witness. We find paragraph 21 as a matter which has its foundation in the pleadings and same is accordingly maintained. As regards paragraph 25, we found that that is the sentence beginning with, quote, in fact, the ever-changing figures, end of quote, to the end of that paragraph is hereby struck out as not based on the pleadings. In respect of paragraph 26, the court is of the opinion that the statement from line 5 above, beginning with, quote, the chairperson of the first respondent, end of quote, to the end of the paragraph is struck out on the basis that it has no foundation in the pleadings. As regards paragraph 28, from line 6, that is the sentence beginning from, quote, the secrecy and the lack of transparency to the end of quote, to the end is not borne out of the pleadings, and we accordingly struck it out. In respect of paragraph 30, the court is of the view that it has no foundation in the pleadings, as it just refers to CI 127, which the witness cannot testify on the statute. As regards paragraph 32 and 33, we found that they are based on the pleadings and therefore ought to be part of the witness statement, and they are accordingly maintained. In respect of paragraph 37 of the witness statement, we found that it is just an inference to be drawn and not evidence. We therefore proceed to strike it out. The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PW1.
And Lords, we are most grateful.
We are most grateful to the court. As the court pleases, and just for the sake of clarity, I would like to understand what was said in respect of paragraph 30. Paragraph 30, because the reference to the regulations in CI 127, that's in the first sentence, but the rest of the paragraph, including the exhibit C, is not related.
Yeah, the whole of paragraph 30.
The whole is in,
yeah, it's
the whole of paragraph.
Yes.
That's the whole of paragraph 30.
Then you must look where those that are
Now, the 2020 December 7 elections was conducted under rules passed by Parliament. Is that correct? The 2020 December 7 elections were passed, was conducted by rules passed by Parliament. Is that correct?
That's correct.
My Lord, it is supposed to be conducted by the rules, but we have issues about the application of the rules in the conduct of the elections.
CI 127 is binding on the petition. Well, yes, it was 6 pounds, sorry. The petitioner appointed agents for each of the polling stations in the country. Is that correct?
That's correct, my Lord.
How many agents did the petitioner appoint for each polling station?
2 agents.
Now, at each polling station, the petitioner and indeed all the other candidates had agents. Is that correct?
I cannot speak for all other candidates.
Now, you trained your agents on what their duties at the polling stations would be.
Yes, my Lord, that's correct.
You trained your agents on how Forms 8A and 8B was to be completed in each of the polling stations.
That's correct, my Lord.
You trained your agents on how each form was self-auditing and designed to reduce errors and mistakes. Is that correct?
That's correct, my Lord.
You also trained them that at any point that they had a problem with what was happening at the polling station, they could refuse to sign the form but state the reasons for it. Is that correct?
That's correct, my Lord.
You also trained them that if they stated the reasons for not signing, the issue will be taken up at the constituency collation centers. Is that correct?
That's correct, my Lord.
You also trained your agents that at the end of counting and entering of figures, they collect their copies of the Form 8, whether or not they signed it. Is that correct?
That's correct, my Lord.
You also appointed agents for each of the 275 constituency collation centers. Is that correct?
That's correct, my Lord.
You trained them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency collation centers. Is that correct?
That's correct, my Lord.
You also trained them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my Lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency collation center. Is that correct?
That's correct, my Lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my Lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my Lord. But all with the involvement of our agents.
Now, you also train them that if they have any issues with Form 10, they could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Now, you also train them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my Lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Right.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together, and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known, but that is not the declaration of the presidential election.
Okay, good. You trained your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated onto Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the collation, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional coalition forms, your agents signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed, it was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed a form for Central Region, is that correct?
That's correct, my lord.
Your agent signed a form for Western, is that correct?
That's correct, my lord.
Your agent signed a form for Savannah, is that correct?
That's correct, my lord.
Your agent signed a form for Volta, is that correct?
That's correct, my lord.
And your agent signed a form for Bono East, is that correct?
Bono
East.
Bono East. Bono.
It was signed by Ali Mohammed Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Collation Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the collation. Is that correct?
That's correct.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right, okay. Right. Now, are you aware that at the National Collation Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Collation Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, my lord.
Dated 9 December 2012. I suggest to you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My Lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in two parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D.
Yeah.
Would you be kind enough to tell the court the person who signed this letter?
My Lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my Lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Jemfi. Do you know him?
Yes, my Lord.
And I'm further putting it to you that Ashanti was signed by, was certified by Mr. Rojo Metonunu.
My Lord, the agents who come subsequently will be able to confirm that or deny it.
Do you know whether Rojo signed or not?
Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Broja Jemfi, Rojo Metonunu signed against it. Do you know or you don't know?
My Lord, the documents that come to our notice is the final declarations, the signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Broja Jemfi in Ashanti region, and
yes,
when it was transmitted, and when it was transmitted to the strong room, as you call it, Mr. Rojo Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the Eastern region. Is that correct?
That's correct, my Lord.
On the first sheet, your agent signed the form. Is that correct?
My Lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one. The one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my Lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My Lord, I have realized that the totals there are. Yes, I've looked at. Yes, my lord, that is precisely what I'm about to do. I have done the collations, the additions, and I've realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1196751 and not the 1236940 that was written on it.
My lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My lord, my lord, we brought the calculator.
Yes.
If the court will permit, he can do that.
Yes.
Order in court, please. Order.
1, 4, 6. Services. No. Appears your calculator is not 1, 2, 9.
Is order in court.
Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1236940. What will you arrive at?
40,109.
40,109. 189.
189, sorry.
It is 189.
Yeah.
Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence. Yeah, listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, thus making extra gains to make the total valid votes 1, 2, 3, 6, 940. I am putting it to you.
My lord, can you come again?
I am putting it to you that when Ayenswano results that I have just shown you, that if you take the difference that you got from the first sheet, from you get 4189, and that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 940. And I'm putting that to you.
Yes, my lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem, for which you ought to have written to the first respondent.
I deny that, my lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My lord, I repeat that if the figures are in contention, It is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My Lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my Lord. Well, my Lord. Well, my Lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. Well, I am putting it to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rojo Metonunu in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court. Paragraph 12.
Yeah, I'm ready.
Paragraph 12 of the amended petition, sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 30,121,101. A figure that is completely missing from the purported declaration. 111. A figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020 and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid votes, total valid votes, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111
was the correct total valid votes that ought to have been announced on the 9th, as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metununu and Dr. Pesa White, left the strong room. Is that correct?
That's correct, my Lord.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My Lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
My Lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, they would have seen that those figures, 13, 121, 111, was the total valid votes as captured on Form 13.
My Lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My Lord, I have indicated that the processes within that National Collation Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Techiman South constituency, not so?
My Lord, I'm not the petitioner.
Okay, we'll leave it.
Now, let me refer you to your form, your Exhibit E. Look under Bunu East. Bunu East.
Yeah.
do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you. There's nowhere in the evidence that you purport to say that the petitioner got all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness. Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court. My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenubo, please.
Yes.
Reframe the question.
Now, yes, my lords.
He's raised an objection. What is your response to that? You are reframing the question.
Lords, I'll rephrase the question.
Okay.
Right.
And then tell me that.
Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time
you were
filing the witness statement?
Yes.
Yes.
They were known?
Yes.
Good. I'm further putting it to you, therefore, that as at the time that the petitioner filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of the Chimain South, they feel secure to proceed because even if all the votes of the Chimain South were to be added to the petitioner's tally, it will not change the outcome. Yes. So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew? Because I didn't do declarations.
You, as the witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 13,121,111.
Yes, because you stated so, the petitioner stated so in his petition, that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord, you see,
answer the question.
I don't understand why you seem to be confusing me with the petitioner. because I don't understand.
You see, that's why we have to strike out some of the evidence, because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Oh. Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner, right. And I'm saying that I'm not.
So,
I took these figures from the respondent's declaration.
Now,
and before they were declared, I couldn't have known what he was declaring.
Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates. On my witness statement, okay. Witness statement. Have you taken? You've taken the witness statement. It's over there. Let me show you. Bring book. is here. Paragraph 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe-Mensah as cast, which is 13,434,574, the resultant figure would now be 13,562,592. Consequently, if all the votes of Techima South constituency were added to petitioner's votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techima and South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and then you can explain.
Okay.
Answer the question. I'm saying that at the time you were making this statement,
yeah,
you knew the exact results of the Techima South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techima South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techima. The respondent was justifying why she had to declare results based on uncompleted tally. And we are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that also?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
And I'm comfortable, I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total.
Yeah, the
total valid votes.
Yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to these documents submitted by the first respondent.
Now, it is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way they have rendered it, that's why.
0.51.
Yes.
63.
0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
A percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
That is correct.
Yeah.
Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned from assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage. You are now asking.
7. Yes, I've moved on from percentage. 6776066 minus 6265276. What do you get?
677.
As it's not that good, I think you'll be stretching the witness.
About 510,790.
Thank you. Thank you very much.
It's okay.
Yes. It is, you got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My lord, I decline that assertion.
Now, in your Exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where padding took place. I did not indicate that that is an exhaustive list of all the places where the padding took place.
Sir,
we
are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicates that this is from a sample of this particular constituency. I don't understand sample to mean a total of the population.
Now, deduct the 510,790, you deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the
with the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4693 from 510,790. What do you get?
693. I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My lord, I deny that because that you are subtracting apples from mangoes. To 1 point. But this is a sample. You want to take a sample from a population of another group. I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My lords, on that basis, I'll end my cross-examination of the witness.
Yes, my lord, I do. So, Mr. Seydou Nkatia, you recall that before the declaration of 9th January 2021, 9th December 2021, oh, relax. 9th December 2020. Your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My lord, that is not in my witness statement.
No. Where is it? Yes, the paper. So can you answer that question? You did say so, didn't you?
Come again.
I said your party, including your good self, and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your as deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is the petitioner, asserted that he had won the 2020 presidential elections.
My Lord,
Ghanaians had voted for change.
My Lord, what I remember the petitioner said was that the results as declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
My Lord, unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My Lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My Lord, if I meant that, I would have said so.
Mr. Asedun Petia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My Lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent, we have attached Exhibit 6.
Exhibit
6.
This one.
Yeah. It's hours. We're looking for hours. Yes, can you answer?
Yes, I've seen this in a brown envelope.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lords, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we lead that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that you will exactly. Yes, my Lord. Very well. Yes.
Mr. Kutuampa.
Yes, my Lord.
You are conducting your case. So if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you've not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My Lord, may I, with your leave, make an oral application to have the video that we've attached to our witness statement played out, so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video,
my Lord,
establish?
The relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election, and that there was an attempt by the first respondent, together with, in collision with the second respondent, were trying the will of the people, and that they had all the necessary pink sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won, come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so there should be a rerun. It goes to their faith, good faith and credibility.
But
in this matter.
Mr. Kutuampa, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I have won an election, that should be taken as the law?
No.
We have laws, we have regulations, and how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kutamba, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in.
No, yes. My lords, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it because it's part of our case, and use it to cross-examine the witness. And my lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes. So you haven't said so.
No, my lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
My lords, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is for leave for the video.
Confront him with the exhibit.
Yes.
Okay.
Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of, and I have every reason to presume that you know that we'd like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I always take an adjournment.
My lords, I respectfully, I believe that we have not been heard. There have been several steps of questions and so on. We have not been heard even in respect of his basic attempt. Okay.
Submission, the application. He said he was making an oral application.
Right.
Yes.
Yes, that's why I was saying that
My understanding was that the question from His Lordship Justice Amegache was about the practicality of implementing that.
Yeah, it has not been granted. So we have to hear you before we can rule on it.
Very well.
Yeah, okay.
My Lord, in the first instance, it is the case of the petitioner that is being made by this witness. And therefore, evidence that he says is part of their case, that evidence has not yet come in. And your Lordship will see that, in fact, literally, whilst in the box, he opened that envelope. I mean, it was clipped. I think we all saw that. It was clipped, and he answered that, I mean, he has not seen that tape. So, my Lord, in terms of the answers that he's given when the matters have been put to him, he has answered those matters. Now, the question now it is now being proposed that even before they bring in their witness statement with this flash drive, it should be put to him. That witness statement is not yet in evidence. It's not been adopted in evidence. So how my Lord, with respect, the procedures are simply being confused.
From this witness statement, which is, would I say, an invention into our rules. Well, you see, in some years back, before the coming into force of the, is it CI 87? CI 87. Yes, you can just ask a witness under cross-examination that, please look at this exhibit. Did you append your signature to it or whatever? That was the practice. But yes, then you may even tender it through the witness under cross-examination, which was permissible. But of late, because of the CI 87, it is.
You remember, if you are conducting cross-examination, if you remember, you can pull out a document.
Yes.
And show it to the
witness. Yes.
Yeah. That document may not be in evidence.
My Lord, I have absolutely no problem.
So it's the same principle.
No, my Lord, with the greatest respect, what he was showing the witness was an attachment to a witness statement that has not yet been adopted. That's very different from the...
So it is not evidence yet. It's not evidence yet.
No, my Lord, with the greatest respect, I'm saying that your Lordship has described a scenario which is clear in terms of the procedure other than the procedure that is being used now. In that procedure, that evidence would not be part of a witness statement or anything like that.
Yeah.
It would be a document that in itself can be tendered through the witness. And I don't have a problem with that. I'm just saying, my Lord, and I think with the greatest respect, this is also an indication of a problem arising from the fact that the case management process was truncated, with the greatest respect. Because, my Lord, in the case management process, you would normally be able to indicate these materials which you would want to put to the witness. Then in the case management process, your Lordships would have the opportunity to make this practical arrangement that was being described by His Lordship Justice Amegache, whereby if that is a document or that is a video that they want to show and so on, that as a piece of evidence to confront him would be catered for. So, my Lords, I'm respectfully making two very simple points. Firstly, in terms of the procedure that he's seeking to adopt, bringing in a witness statement and an attachment to the witness statement, that is irregular. Secondly, because that witness statement has not been adopted. So
it's not evidence yet.
Yes.
That is why they can do what they are doing. Because it's not evidence until they come to the box and adopt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document. That document is not in evidence yet.
That is why
so we are speaking the same. We are on the same level. We are on the same wavelength. What they have now, even though it has been filed, is not evidence. So they have it.
Yes, but my Lords, you heard him. The application that he made is that it is part of our case that so and so.
Yes.
He said that.
Yes. So it's just electronic evidence. If it were any ordinary document, he could just give it to the court clerk to show it to Mr.
Yes, my lord, as you said, we're on the same wavelength in terms of the practice related to showing a document, a video, or whatever. We are absolutely on the same level. I'm just referring to the way in which he sought to bring it in through referring to the witness statement, which is not yet in, to a witness who is under cross-examination as the petitioner's witness. That's all. But, my lord, clearly, documents can be put to the witness under cross-examination. I don't have a difficulty about that. That's why I was saying that the practical problem that we're in right now is because if in case management it had been understood, and I believe that was the question that His Lordship Justice Amagashi was asking, if it had been understood that that document would be required for the cross-examination, then arrangements would have been made practically for that, because it happens to require some technology for it to be shown. So that is what I'm saying. And so we are in a situation where, you know, the practicalities do not allow for the procedure that your lordship is referring me to, which I agree is a procedure that can happen under cross-examination. But because of the way that it was sort of introduced, we've ended up in this situation. So if we can, I suppose, go back to some case management and so on. And I mean,
all we need to do is to secure the equipment that can be used to play to the video to the witness. That is.
My lords, it was precisely because of this that when I got up, I sought to have directions of the court because of the new novel processes of witness statements and what it means for putting your case to.
Mr. Kotampa, even if we were not in an era of case management prior, where you bring all you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
We have actually notified the registry that we would be needing Very well. Very well. My lords, but that is why I made the application. Oh.
My lords, once you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which he has testified and which is part of our witness list, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because whilst we're discussing all this technology, I think very well. Exactly, that's all I'm saying.
By court, counsel for the second respondent wants the court to have access to the content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be placed on the next adjourned date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination. Please, we've not been discharged. Yes. So Monday, they may continue to conduct the cross-examination.
Very well, man.
Yeah, I will tell you.
We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well.
Thank you for your unsolicited assistance. Danny?
All rise.
has been adjourned to Monday. But we'll take you through what happened. Whilst we were actually doing this before, we were told that they had to quickly move back to the Supreme Court. It's got to do with the various objections raised in the petitioner's statement. And the courts came back and they had to strike out some and also maintain some. So we'll start off with the ones that they are
gentlemen of the press, and by extension the entire Ghanaian public. After a long day in court, the justices of the Supreme Court have had to adjourn the proceedings of today to Monday, the 1st of February 2021, to enable second respondents team play a video which was annexed to the witness statement. You all saw the proceedings in court through the morning to this late afternoon. We started by the second respondent objecting to offending paragraphs in the witness statement of Johnson Asiedu Nketia, the General Secretary of the National Democratic Congress, on whose ticket the petitioner John Dramani Mahama stood as his presidential candidate to contest the December 7, 2020 elections. Out of 10 offending paragraphs, the court graciously admitted 3 of the paragraphs to remain and 7 7 of the offending paragraphs were removed in part, but 1 of them was totally expunged from the witness statement. It is pertinent to state that 1 of the offending paragraphs related to the pedestrian allegation of Asiedun Ketia in his witness statement that the chairperson of the Electoral Commission has a familial relationship with Her Excellency the First Lady of the Republic, Mrs. Rebecca Akufo-Addo. We all witness the strenuous and tedious submissions by petitioners' lead counsel to answer to the objections which had been raised to portions of the witness statement. It was a repetition after repetition, which prompted lead counsel for second respondent, who could not bear it any longer, to remind the court of the petitions, of the repetitions. When Mr. Johnson Asiedun Ketia took to the witness box, he remained largely evasive. Every question that was posed, his immediate response is that I do not speak for the petitioner. This is someone who in paragraph 2 of his witness statement has stated clearly that he was in court to end or lend aid to the petition filed by petitioner. How can you come to court as a witness for a party, and when you are asked questions in court, your response is that I don't speak for the petitioner? Then why are you in that court? Why are you then in the court? He thinks he can be as elusive and invasive as he was in 2013. This time around, he will not be lucky. Now, it is very instructive to let all Ghanaians know that the one person who filed the petition, which is John Dramani Mahama, has refused, failed, or neglected to sign onto a witness statement. As we address you this afternoon, the petitioner himself has no witness statement before the court. This is a petitioner who seeks to have the elections annulled and is praying for a rerun. This same person is refusing to come and give evidence in court. The judgment is with the Ghanaian public, not mine. When Johnson Asiedun Ketia went all about town, he said one thing which is poignant. When he was posed a question by a lawyer for first respondent, his response was that we are in court to challenge the conduct and constitutional duty of first respondent. We are not in court to challenge the elections. I mean, that is Johnson Asiedun Ketia's own statement, not mine. We are in court to challenge the conduct and constitutional duty of first respondent, not the elections. So this is where we are. As I always do, I will allow you to ask questions. if any?
First question.
At the latter part of proceedings, you made a request, wanted to confront the witness with a certain video. I mean, we're just wondering how exactly does that help your side of the story? Because the contention that they have put in their petition in terms of what they have filed is to make the case that...
Can you repeat your question again?
Yeah, I'm saying that at the latter part of proceedings, your side put in a request for a certain video to be allowed so that you confront the witness with it. I'm only asking you to explain to us how relevant it is to the case, in that the substantive matter that is before the court is the claim that no one had more than 50% of the votes cast, not the claim that no one won, like that someone won by more than 50%.
In court, the test for every witness in court is the witness's credibility. So you realize that when we went on and on and on, the final leg of the submission was that we want to attack the credibility of the witness. And it was at that point that the court was minded to grant the application for a play of that video. Now, the relevance, to you it might not be relevant, but the relevance is that these are persons who, after or during the course of the elections, had proclaimed to Ghanaians. In fact, the presidential candidate himself, John Dramani Mahama, the General Secretary, Johnson Asedun Ketia, the Deputy General Secretary, Otokuno, the Director of Elections, Elvis Afi Ankra, and their communication officer, Sami Jemfi, had proclaimed to the whole of Ghana and the world that their presidential candidate had won the presidential elections, and they had secured, some were saying 140 seats in parliament, others were saying 141, others were mentioned that they were not even sure. And when they proclaimed that they had won the presidential elections, they gave you percentages. Don't pretend as if you didn't hear. They gave percentages. And some of them were calling the presidential candidate president-elect. I think I recall Sami Jemfi, a communication officer, referred to Mahama as the president-elect. Some of them even urged him to form a parallel government. Now when they are being invited to the police, there's another story. They advised him to run a parallel government because they had won the elections. Now these are the same South people who now, when come to court, cannot even tell how many votes they garnered and are asking for a rerun. Does that sit well with you? And you think it sits well with Ghanaians? No. But you see, I must point out also that the exhibit that Asiedun Ketia was confronted with was their own exhibit. The exhibit E. It was their own exhibit. In his testimony, they failed to sign on to regions where it was abundantly clear that the petitioner had won elections there. Their agents in the strong room decided to take a long jump when they realized that the results proved unfavorable in their cause. That is my answer.
All right. My question is in reference to the claim, the remark that you said Mr. Johnson Asiedun Ketia made in court. Indeed, what we heard him say was that he is not the petitioner and not that he does not speak for the petitioner. You are lawyers. When somebody says, I am not this person, it's different from saying, I do not speak for that person.
Have you read paragraph 2 of his witness statement? Maybe if you read paragraph 2 closely, on Monday when I come, we can have that engagement. But when somebody says that the petitioner stood on the ticket of the National Democratic Congress to contest the elections, and I, the General Secretary, the Chief Executive Officer of the party, I am swearing to a witness statement to give evidence in support of the petition filed by the petitioner. Would you still want to maintain your question?
Well, I just want a difference to know the difference between when someone says, I am not the petitioner and I do not speak for the petitioner.
A witness only corroborates the case of the party. You don't become a witness in court because you have sprung up from somewhere, maybe from Mount Kilimanjaro. You become a witness because there is a necessary party in the case. John Dramani Mahama has not donated a power of attorney to anyone to speak on his behalf. It is Johnson Asedun Ketia and Dr. Kwesa White who are coming to speak as witnesses. And they all state that they are speaking in support of the petition. So you cannot come to court and lend aid to a petition, and when you are asked questions in court, you say, I am not a petitioner. So what are you? Are they aware of someone?
Okay, that's it. Thank you very much. Thank you.
I would end, as I always do, if you have nothing to say about another person, whether that thing is useful or beneficial, then please do not say anything at all. Because if you invariably say what you want to say, you will prompt the other person to also say something or respond in a way or manner that may or may not just otherwise be pleasant to you. Let's all be guided by fidelity to the truth and don't bear false testimony. Thank you.
Major Chief for the lawyer upon now on Casas here. Lawyer.
Okay. You remember the tougher. Near Ohoni say, Emre Saudi Asemuba Kota. Ese ensem no nyina pese court no egitimu no odi nyina be to court no maybe sade ayechi ni se odi assemble ba na chire no obesisa wano obroni se obe surprise other party no enti empenisa eni ti obehwe a owura Mahama de assembly ba court no ensem bi wo ho a okan nenso owura se dunketia de ne witness statement ne ba no ensem ni bi wo na Mr. Mahama na ankasa aye ni case no wan fanshim Nekobasa na enyese wa surprise yen ye won chen no nko an emom ukrampo ye ma osi ya me ye twam sisi efi se ade emrachi eni so obi di na asema ba na ni witness eni na ji ho achinyi efi se ni witness ne ka no soronko efinia nipa na so de asem no ba ye no e kan ti twakura atwam sisi ne ye efi se enke ewie case ni e tra addresses a enke bi ensem e be ka wo mrakwan so no e ma asem no kure betwam ntam enti bi say say omoda yase yabo a omsabre na ne ho biem ni say senia ensem ni course ne no ubehu say ensembusa no eba no de se bi munyina mo court ho muhu senia no ye ne ko ye wie enti mi nkan kosi ase bebre nanso ba bia ye du ni say ensembusa ne ba ye say eyembra ye to aba ni wie ye no penifo bi e wo NDC mu na Mr. Mahama nkasa former president Omukan se abane de owura Mahama na ewi ni
one touch
mi ni kuma me chia ne sisi asemi jamfi nso kan bi se president elect na akono ye nanso na nipa bebre ehwe ni mu se nka owura Mahama de case ba Supreme Court no obeka se yen twa abatuo num owura Kufuadu anwi ni na mum owura no Mahama no na wi ni na nka yen ka se Supreme Court enkansi so senior 2013 na Kufuadu de ba court no so ekoye nwanwa se omo ba court no owura Mahama se wanwini na mum owura Kufuadu nso anwini enti no eba ne saade a yenkoto aba ne mo mienu nya na gum ne akuadon kom nya enfo mu nsinchen enti eho ne egina sese enti o de tronsem a se bi ono ane na pamfo ekan ya ema supporters bebrani giye eni be bi anka esese otimi kansi so sampa mi wini ene bi ya wia me no antimi ameka se mpo ya wia no na wanso antimi ameka se me na mi wini ye ne ya bu me bukata no eno ne ma krofo bebre adwemu ye omna kakranti Ebi adwada ye bo video no ana tape na. Munyam be hwe bi atie bi. Na se bi munyam ye badwema. Na motimi di mani ni maso nyina abu. Ba bi ejina no no. Tie dem ase.
Good afternoon, ladies and gentlemen of the press. I want to start by letting you know that today was very eventful. And I'm sure when you watched the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensah to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management, as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days. And in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now, it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened. the court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management, that issue would have come up, and the court would have been prepared that on day one of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to underscore the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not. And we will prove that in court. Just watch out in the next few days. Any questions?
Any impact on the case as you have put together?
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witnesses. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right? Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner that was motivated by personal dislike for His Excellency John Dramani Mahama, or if you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement, we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she's a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
So you have made it clear to us that the petitioner himself will not be in the box and that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, the petitioner's witness declared that he was not the petitioner and therefore did not answer certain questions that were thrown at him.
Well, that's an excellent question. It means that you were watching the proceedings. Let me make it clear that in those instances where the witness said that he was not a petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner. Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. How do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our general secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officer. He coordinated the election. So who better to, testify on our behalf than our General Secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the General Secretary was right in declining those questions. Any other question? All right. Thank you very much, ladies and gentlemen of the press.
Okay, so let me just do the Doc, let me do the Abusianfo, your best friend, Yatre, and then the course of the Supreme Court of Ghana, Ewuchi Kasem. Na Sakra na Metre, the Dr. Ayine, Akano Poto Kasem, Wuchi Kasenimuno. Frank Davis oye kasama for Emma the second respondent eye nanado danko akufuado akan sembia e wo se yeyi ano na ma Ghana for anye sebio sa inkuntumpu sem no antum yedi kan samutie ni a o use word bi say about 10 passages na wo General Mosquito witness statement mu no omo ka se court no mungu na court no bomun sungu ye because sansem no a pedestrian chese sebio e yakushisem obusanfo mu nyina mo hwe de course wo court no bi wo TV so court no bo sa nsemfu anso na gu no court na nka ba bia se e pedestrian court na nka se yakushisem omu person ka court no be bo sansem na gu because e yakushisem e scandalous be court na ntie the court no kan ya ne say wabo sansem so no agu because say any your petition the dear friend of pleadings it has no foundation in the pleadings. That is different from say obeka say and someone e General Mosquito adanse crater mu no e pedestrian na ye pay attention and ye raise this issue because of bibi e kwa ye yenuano wa mokasama second respondent suban say maybe a ye be free court aba ha bia no omo be yusu kasetwie ene sebin semwa eni say free a lawyer for ano e de akasa fa de course wo court. The last time it was intransigent and right it was somebody who had a jaundiced mind and there will be a ne passages here pedestrian ye be sere ni diem say a lawyer for we are this year money atete ye wokwan ya wase ye faso kasa enu nti se wo free court na waba be kan semwa akoso wo court wa the court nkan ye no enkan she court na no if the court in dismissing or upholding those 7 objections no did not say a pedestrian imagine bedwem meka that conduct no is unbecoming of a lawyer of the standing of Frank Davis. Ye be stress ye nyina ye be condemn se na be ya enkoso because ebetimi aha asemo a court no edi de atoso biem o ka se o mampanyi John Dramani Mahama ode na asema ba court o ye petitioner no on fa dance krata bia maye enu nti no no kire se oni asem bia te se de doctor yi ne chechire mu opoto kasam no sa asem ne so eye mfuturu a ye nuanom etugu Ghana fo ani because wo mramu no so what the was send beto court and him say court on kawasema as petitioner bibia ni we hye say e wo say wa obedi adanse ma ho emrane ma ho kwan say utimi fra adansefo ma adansefo e bedi adanse ma ho enu nti na in 2013 election petition no o mampenya kufu adode na assemble as the petitioner no ono wa medi adanse ni bi wa ma obi aso mra krata the friend of power of attorney say o megina nenamu eya dansefo Dr. Bawomiamo eno from mo hu bedi adanse ma no enti de yewura Jo Mahama aye no edimu ewo mramu a bibibo ne bi anim ti nsem a ye nuanom kan ne no so no eni nyina so bia wo mram ti e be stress eno so ye de beto nchen ebiem oka se NDC for emra ye to aba ne wie on 7 December ye ka kire wiase nyina se ye coalition ye nkonta ye bu kire se ya win election no but ye ba court no ye ka asem foforo se court no order for runoff na no kire se ye witness asiedu nketia na NDC for ye nya no kwafo obobo ye nyina ye di ne de keka ho abusuafo sa semi a ye nuanom MPP fo aka ne he ya o maka ne babi bebre no the trend part ne say yasem wa ye de aba court no omonti ase yenti aye kasa ne say yasem wa ye de aba court no has got nothing to do with the collation ayaye any ye figures ayewo wo mremu no se obi tia wo na so mprem nu now the a lawyer for friend 2 courses of action against the person wo na wo be choose the wo de baba court kane nti ampa yeah press conference based on pink sheets ne results are your collation yaka say John Dramani Muhammad Nkunim but assemble ya the court and that is not the nature of it. Assemble ya the court no has to do with the constitutionality of the declaration agreement say yes the constitution say who declare obi say wa weni o mampanyi abato a e wo say say nipa kro no wanya emapa no mu ohamu chichemu aduonum ne akire pe ensam ni figures e wa declaration no mampanyi kufu adu anya until we declaration ni tia Ghana mra kunyini 1992 constitution. Not just a mremuno declaration doesn't even exist. So if the declaration doesn't even exist there, then issues about the collation, in the view of our lawyers, so we have elected to challenge the constitutionality of the declaration of Jimensa. That is what is in court. At the appropriate time, say was said. Ya kasa about your collation ya ni dance ya chese ya arena ya beka wasem but let in some way ya kan about the course of court no ya man fa in some way that court nanim which is about Jimensa adwuma waye about wa wabobo any whether or not to say edimu results are declare no edimu ewo emrem abusianfo ebiem omaka say oh Yewura Johnson say nu ketia dance mu no oka say he is not John Mahama the petitioner. Inti no chere say Yewura say dun ketia nim de oka na petitioner ni nim asem. On de ya ne say a lawyer fo a omunim de. Pa omote sansem we ase no. E maybe e be free court aba bia no ma ba no mutum futu Ghana fo ani. Utie de Frank Davis ankasa kan ya. O say paragraph 2 of Yewura ase dun ketia dance krata na wo say he is giving evidence in support of the petitioner. In support of the petitioner doesn't mean say I am giving evidence as the petitioner. What that means is say as a witness, evidence or they support to petitioner in the case what the lawyers will say matters within his personal knowledge. And this will be a question say now what central phone share mu bi ase anajo mama wo bia waje atum e ho no wankasa onye petitioner because I know the onim now baby say the questions fa petitioner no de man kan bibi ana de na e wo ni timiti a wo ye bibi a na je say nsem wo pese wo ka no they are not within his personal knowledge any on wankasa ni ndiem to man wa dance ye kra watomra that should show you say and na ye panyimu pa odi adanse no oye no kwafo he is credible. Say in somewhere within the personal knowledge in Kwano Beka Wasem. Now we say for yeba the course of court ni muno. A course of court no. The mo share ya sem bisa bebre course say agents assign way which train new agents or munye which new. They said the general secretary kan no. Ye ni nyina. But the same way the aba court no has got nothing to do with that. Obe bobo aba on 9th December. Eka kire Ghana for so mampenye Kufuado awene. We see total valid votes a wugina so ka se wawene no. 13,434,574. Ye kwaye nkonta wankasa waye no o declaration ni mu a o mampenye Kufuado awene. Per wankasa wu figures. Percentage awodi ama no enye correct. Assumption why say the Techiman South nyina ka ne ho a still candidate Mahama Nsa ne ho enye correct. Kwansi ma de achen ya na wasan so at the press release anokra de obi ansan shase aba. And also total valid votes are what they boom kunta ka so mampenye Kufuado awene yesen a. They say they anya 13,434,574 biem. Almost say 13,119,460 na figure na sesa. And no maka chama Ghana for nyina gie di se oh ma me ne yemfonso wa correct ne mfonso afei Yewura John Mahama e de asem we ba court ya se ma meji mensa be kire yen emadodo a wugina so di declare se John Mahama rene a correction na nado arene a correction or yeah no 10th December and no Ghana for mu nyina magye di say no na real results no what paragraph 12 and paragraph 24 of her answer to the petition or they say the figure no and yet 13,119,460 now can the 10th no na 13,121,111 that is the figures na yemiensa after your website also with the 275 constituency summary sheets agu obia betimi akwa na wakan ne wahu abato no nsunsanso ne yekọ keka siani a total valid votes ne yesen a eno so 12,218,633 because abato ba kwa yato o results nko aboro 9 ne akire debia esesa na eno nana Yewura Johnson na Sedu Nketia eka ho asem say that is the issue before the court and we are saying say Sabutie maame nankasa nu mu asem ni figures or the two dwa no na eno ne yesi ye de be ye adwuma de a ene eno mampanyi Akufuado enya more than 50% of the total valid votes eno nti wani nkunim nti abusuafo de ne course so court in the court tu ahye se ejoda ye beba na Yewura Johnson na Sedu Nketia waba ababetoa na dance so na yeba eno so de besi bia no ye ne mo ebedi hu komiti adam wase.
Thank you.
Sorry.
You are going to. All right. Thank you very much. And that was the two press conferences held by the petitioners' side and that of the second respondents, and of course the case has been adjourned till Monday the 1st of February for cross-examination of the petitioner's witness, in this case the General Secretary of the NDC, Mr. Johnson Sedu Nketia, to continue. He was first cross-examined by a lawyer for the petitioner himself, Mr. Chachuchi Kata, and then by a lawyer for the first respondent, lawyer Justin Amenuvo, and then Mr. Akoto-Ampao, the lawyer for the second respondent, began his cross-examination but did make a request for a tape to be played. Facilities for that tape to be played were not immediately available, and the court has adjourned till Monday, and that's where we will bring the coverage to an end. We'll return on Monday to bring you all the other details. Thank you very much for being a part of this coverage. See you on Monday. Welcome back to our studios here at the Ghana Broadcasting Corporation, Ghana Television for that matter. If you're watching us, we're also live on GBC News.